All right, we're here on a couple of different motions. One is Ms. Edmondson's motion for temporary orders, and then there's also Mr. Brogan's motion for change of venue to Grace Harbor. So just checking with the parties, Mr. McNeil, is that your anticipation? Those are the items we're addressing today?
Yes, Your Honor. It was venue and then entry of a temporary parenting plan.
Okay, very good. And it looks like the child support has previously been entered, correct?
That's correct.
Okay. All right. And then Ms. Edmondson, from your vantage point, are those the items that we're discussing today?
Yes, Your Honor.
Okay.
And the guardian ad litem, I believe.
Right. As far as a motion for the appointment thereof, correct?
Yes, sir.
Right. Maybe we can address that first. Mr. McNeil, do you have any opposition to the appointment of a guardian ad litem?
I don't necessarily have any opposition to the appointment. However, costs are a concern here. The court may have, if when reviewing the file, looked at the financial declarations of both parties. Ms. Edmondson is receiving public assistance, and I know that they have a provision where she's supposed to be either seeking employment or vocational training. I don't know if she's doing that. I don't think she has funds to pay for a guardian ad litem. Mr. Brogan's in a similar situation. He was going through his treatment program, and he was getting a commercial driver's license, and he's not quite gainfully employed just yet. So I don't know how much that costs, and I don't know what the payment schedule, and I don't know how the court would apportion those funds. But I'm sorry. But in terms of objecting to the appointment, no, but it's the costs that I think are going to be an issue.
Okay. At this point, I will appoint a guardian ad litem, and I'll appoint it at county expense. So for both. So that means that the county covers the cost for that. So then we need to talk about who's going to be appointed. Generally, what we do, we have a running list of the guardians ad litem, and so we have the next three that are on the list. Each party has the opportunity to use a strike to get rid of one of the persons on that list. And so I'll have the clerk read out those three names, and then either of you can exercise strikes if you care to. If not, then I'll just be the first person on the list.
The next three names are Heather Hill, Beth Fellows, Amy Turnbull.
Okay. So I'll turn to Ms. Edmondson. Do you have any individuals you'd like to strike?
No, Your Honor.
Okay. Mr. McNeil?
So I'm not familiar with that panel, Your Honor, and I didn't hear the names to see if I could recognize any of those names. If the court could repeat the names, your microphone I can hear. I couldn't hear the court's microphone or the clerk's microphone.
Heather Hill, Beth Fellows, Amy Turnbull.
Yeah, I'm not familiar with any of those, Judge. I guess I would ask if I could reserve and send an email as if we were going to strike one. I'd like to network with one of the local attorneys, one of the family law attorneys, to find out, if there's one of the guardian items that may have a bias or, would be more appropriate than another. Some of them are more active. So I'm not familiar with any of them.
Okay. I think that probably puts both parties in a similar position. So I don't want to delay the appointment. So I'm going to appoint Heather Kell to be the assigned guardian ad litem.
Judge, will the court, I know there's a mandatory form order for that, but here in Grace Harbor, we have our own local form. Do you have a local form for the appointment of that? And will the court generate that form, or should I do that? Let
me take a look. I think I have a form here in my form file. It looks like looks like our appointed guardian ad litem is on the line.
I am, Your Honor. Can I ask a brief question in regard to that appointment?
Yes, please.
I'm curious about Your Honor's expectation of timing for the case. My caseload right now is actually quite extraordinary. I'm a little concerned that I wouldn't be able to deliver timing wise for probably another month before I could get going on the case. I just want to be upfront about that going into it. If one of the other guardians has a lighter caseload, I'm not sure that'll be true at this time of year, but if that's possible, it may be a better option for this case.
Okay. So your indication is that you for the next 30 days, you wouldn't even be able to get started on it, correct?
Most likely, yes, Your Honor.
Okay. Is that raising issues for either party, Ms. Edmondson?
No, Your Honor.
Okay, Mr. McNeil.
I guess it just depends how the court rules on the temporary parenting plan. I mean, if the court adopts the father's proposed parenting plan, obviously, no, we don't have any objection at all. She could take even longer if she needs. But if the court's going to be in a restricted parenting plan where the father's not seeing his child or it's being supervised, especially based on what's before the court now, then of course we would want a GAL investigation done as expeditiously as possible.
And then if you were able to get involved or have some type of starting point at, say, in 30 days, I know it's hard to estimate, but if it was 30 days, would it be another 60 days for a report? And I know that's highly dependent on the number of people you need to talk to.
Yeah, I mean, without knowing much about the case, I can't make any promises, but if everybody's participating and I can get access to documents and people are participating, then I can do a report in 60 days. It's possible.
Okay, all right. Let me go back to Mr. McNeil's first question related to the order appointing a guardian ad litem. We do have I think it's the state form, but it has some tweaks specific for Dallas County. So I have that particular order here, so I would be filling that in. But as far as there's the kind of a schedule that we're looking at, and this is pertinent to the issue of timing and when the guardian can get to the case, would be a 30-day review of just compliance with the order, basically making sure everybody's contacted the guardian and that there's good exchange of information going on. And then there would be an interim review of the interim report, and then a final report review. So generally, those are those 3 days that we set. The 30-day review obviously is about 30 days out to make sure everybody's compliant and sharing information. And then thereafter, the interim and the final, that's we can kind of tailor it to the particular case. So with that, recognizing the limitations on the potential appointed guardian's schedule, does either party have any concerns or suggestions as for timing?
I don't have anything, Your Honor.
Okay, Ms. Edmondson.
No, Your Honor.
Okay, let me just take a quick moment to write down the cause number on this document. That'll serve as a prompt to me once we're done with today's hearing to finish out the remainder of it. Okay, great. So I think at this point, I'll go ahead and we'll stick with that appointment as originally appointed, with the limitations noted by the guardian, the appointed guardian, as far as timing. Okay, so with that, then let's go ahead and hear I guess we should probably hear the motion to change venue first, and then we can hear the motion related to the temporary orders. So I believe, Mr. McNeil, this is your motion related to the venue change, and then we'll hear from Ms. Edmondson.
All right, thank you, Your Honor. So this case originated in Grace Harbor County. Both parents have substantial ties to the community. The father went to high school here. His family lives here. He has no ties to Cowlitz County whatsoever, and hence all of the witnesses that are aware of these folks, their interactions, and especially what happened prior to separation, are here in Grace Harbor County. Miss Edmondson has her father lives here. There's a sister lives here. There's a grandma lives here. Uncles, she has friends, and she has nieces and other relatives that lives here. She has come here since moving to Cowlitz County. She's been here on visits with the families and her friends. They have a lease agreement with a home here. The child only lived in Grace Harbor County, did not live in Cowlitz County. The only connections, it appears, that are in Cowlitz County is there is a grandmother and an aunt that have a shared residence, and that's where Miss Edmondson went to. And it appears the reason she went there, when she had plenty of other options here in Grace Harbor, was quite simply to withhold visitation from the father. And as you know, Judge, that's a limiting factor. That's not a positive to run with a child, go to a different county, and then quickly file something there. We tried to file something in Grace Harbor, and the database picked up the fact she'd already filed in Cowlitz, and they wouldn't accept our filing. Otherwise, we'd already had this thing up in Grace Harbor. All of the information regarding her drinking and her driving, her drug use, the people she was using drugs with and getting it, her maintaining of the house, the terribly messy house that she lived in, her taking the van and running it out of gas, and the beer bottles and things that were in the van after she'd been driving with the child, things as dropping the child off the end of the bed. I mean, all of the allegations that we're going to be raising here in terms of that parenting plan occurred here in Grace Harbor. And so it's just pretty disingenuous for her to say, well, she's going to run the Cowlitz and then force the father then to incur the time and the expense. And all of the witnesses, except for the grandma and the aunt, are in Grace Harbor. So we're asking that the venue be changed here.
Thank you, Mr. McNeil. Could I ask a question? Does Grace Harbor Superior Court, does it offer remote proceeding access or Zoom hearing?
Yes. Yeah, absolutely.
So if any party anywhere in the world, they could Zoom in and participate in any of the proceedings there.
And funny you should say that. We have a guardian ad litem who likes to travel, and she does Zoom in from all over the world. So Yes, the short answer is yes, we do have that. Zoom's not going to go away anytime soon in Grace Harbor. I think it's here to stay.
All right, thank you. Ms. Edmondson, what's your take on the motion?
Yes, Your Honor. I don't believe the change in venue is necessary or beneficial for this case or my son. My son and myself are residents of the Cowlitz County. He has a doctor. I have a doctor at the Family Cowlitz Health Center. I have a DSHS caseworker. I have a domestic violence advocate that I see and a counselor at the CMAR that I see. I don't see a reason to change the venue, Your Honor.
So just quickly in response, Judge,
So hold on, if I could just interrupt, I apologize. Ms. Edmondson, you moved to Cowlitz County living with your grandmother and your aunt approximately in what month?
I moved in May, Your Honor, to my aunt's.
Was that the end? You indicated in your pleadings that the lease ended sometime around mid-May, May 16?
Yes, Kenneth Brogan terminated the lease May 16th, Your Honor.
And then when did you move to the Longview, Cowlitz County area?
May 10th, Your Honor.
May 10th. Okay. All right. Thank you.
So,
go ahead, Mr. McNeil.
Judge, in response to the medical, all the prenatal care occurred in Grace Harbor. All the obstetrics and all of that occurred here in Grace Harbor County. The birth was here in Grace Harbor County at our local hospital. The aftercare, having the baby, that all occurred here in Grace Harbor. The pediatrician was here in Grace Harbor County. The only thing that occurred in Cowlitz was when she moved, she then had to get another medical provider. But all of that, all of the history, the significant history in this case, was here in Grace Harbor County. In terms of her social worker and her access to public assistance, that's through the state of Washington, and we have a well-established network of public assistance. We are not a wealthy county here. There's quite a few people that are on public assistance, so all of that would be available. And frankly, it would be even more convenient for her because we have an excellent public transportation system here, and they have the office, which is centrally located. So she would not be compromised in any way by coming back to Grace Harbor. And in fact, there would be a better history of what's going on in this case if she were to come back to Grace Harbor with her medical.
Your Honor, if I may, yes, Skylar was born in Grace Harbor, but I had to flee. I had to fled because of the drug use by Mr. Brogan. I could not stay in that situation. And he has, the family vehicle was taken from me. I have no means to travel. I have no car. He has 2 vehicles, Your Honor.
With regards to the drug use, Judge,
let me just inquire of Ms. Russell. Ms. Russell, do you have any input on this particular motion?
Only that the state still has yet to be served the documents related to the motion. The state, of course, doesn't take a petition on venue and will remain a party regardless of venue.
Great, thank you. Any last thoughts, Mr. McNeil?
So with regards to the drug use, we have submitted text messages from Ms. Edmondson, not just one, but several text messages where she had been asking Mr. Brogan to acquire drugs for her, that she only needed 2 hits. If you see, I know when the court gets a big pile of text messages, it's hard to go through them for a lot of different reasons. So we've tried to be very concise in the text messaging that we've provided as an exhibit, but we have provided multiple messages from multiple days where Ms. Edmondson had been asking Mr. Brogan, could he please provide drugs to her? The difference between the two is that she has not admitted to using drugs. She has not submitted to any sort of drug verification, no hair testing, no urinalysis testing, and she's not admitting to her problem. The difference is Mr. Brogan candidly admits that they both had a problem. I mean, you've heard the expression, birds of a feather kind of flock together. Well, they had this in common, and Mr. Brogan admits to that. Mr. Brogan went to a treatment facility. He's engaged in a treatment program, and he's provided clean UAs for the court as exhibits. Ms. Edmondson has done none of that, and she has not responded to the multiple text messages where she says, I'm in drugs, I need drugs. In addition, she says she'll commit suicide, that if she doesn't get it, she says she's incapacitated.
How does this pertain to the change of motion or change of venue motion?
Yeah, okay, I'm just responding to her allegations. I apologize, Ron. I got kind of going on that. Sorry.
Right, right. So under RCW 4.12.030, there's some different grounds or bases by which change of venue can be authorized. One is that the county designated in the complaint is not the proper county. That doesn't apply. That there is reason to believe that an impartial trial cannot be had therein. That doesn't apply. Number 3 says that the convenience of witnesses or the ends of justice would be forwarded by that change. That applies. Then it goes on to list some other things about judges being disqualified by some relation or consanguinity. So that doesn't apply either. So what we know is that the parties were together for 2 years. They spent the majority of the time in Grays Harbor, spent some time up in Montana, and then returned from Montana, and then they severed ties or they separated in mid-May, and Ms. Edmondson moved to the Longview area, and Mr. Brogan remained in Grays Harbor. Both were actively involved in their addiction. So that is what it is, and it appears that they're both making efforts to move into the recovery lifestyle and do better. So I'm happy that both are doing that. So one thing is that we look at convenience of witnesses. We look at the information and the ability for witnesses to come and participate in this process. And it sounds like there's a large number of individuals on both sides of the ledger that are in the Grays Harbor or Grays Harbor County area, including Ms. Edmondson's father, a sister, or some nieces, and some friends. There's some indication that she's returned to that area on occasion since she's moved to Longview to visit. And there's also important to note that if somebody doesn't have a vehicle, having access to the courts is an important consideration. Apparently, Grays Harbor County, based on the representation of Mr. McNeil, does provide Zoom or remote access to court proceedings. That's exemplified by his example of a guardian ad litem appearing when she or he's traveling. Ms. Edmondson's lived here roughly 2.5 months. She has some connected with doctors, as is the child, caseworkers, advocates, drug addiction counselors, and the like. I think overall, I will bet on those factors. I will grant the motion to change venue to Grays Harbor. I think there's the convenience of witnesses is important to note, and that'll be more convenient for them. And then also that Ms. Edmondson will have access via Zoom to fully participate in the proceedings. As far as the payment of the filing fee, if Grays Harbor County requires that, then that will be the responsibility of Mr. Brogan. So then let me ask the follow-up. Having made that decision on the motion to grant the change of venue to Grays Harbor, does the court move forward at this point with the motion for Ms. Edmondson's motion for temporary orders on parenting plan and the like? Ms. Edmondson, if you want to chime in, and then we'll hear from Mr. McNeil.
Yes, Your Honor. In the temporary, just one moment. Okay, so Your Honor, in the temporary parenting plan, I have asked for supervised visitation.
I guess before you get into the specifics of your proposed parenting plan, what is your position since I've granted the motion to change the venue to a different court? Should we proceed today with your motion, or should that be paused and have the Grays Harbor County Superior Court address it? That's kind of what I was hoping you could chime in on.
Yes, sir. If we could proceed and get this situated and figured out today.
Okay. Thank you, Mr. McNeil.
Yeah, I mean, my client hasn't seen the child in quite a bit of time, and I was just, while we were discussing, Mr. Brogan's mother is here. She's the maternal grandparent. She's worked for the state of Washington for over 20 years. They have resided with her when they were together. She would be willing to provide supervised visits if that's the concern of Miss Edmondson. It's just that, the health, the welfare, and things, and the supervision of the child. That's happened in the past, and it was never a problem before. They've lived with the maternal grandmother out in Montana. She would be willing to do that as a stopgap measure until we can get back into court again and have a more thorough discussion about it.
Thank you. Ms. Edmondson.
Your Honor, in one of my proposed parenting plans I have made, Mr. Brogan refused mediation, where I did say I would accept his mother as a supervised visitation, and he did not want that. So I tried bringing.
Okay. All right.
Your Honor, sorry. So sorry. It is not my intention to keep Skylar from his father. I want him very much involved, but it needs to be safely and sober.
And if it sounds like you're in principle, you're okay with the maternal grandmother, you're just pointing out in times past, you proposed that, and he said he didn't really go for that at that time, correct?
Yes, Your Honor. And it came to my attention that I'm not sure she was even in Washington. She goes to Montana very often. So.
Okay. So So I think this is my take on things. With the granting of the motion for the change of venue, I think that it provides a greater seamlessness if the one court makes a decision on a temporary parenting plan, and then there's later information and maybe a potential final parenting plan is decided upon. When all that happens in the same court, I think my sense is that there's going to be a better result, that there's not going to be information lost through the seams. So for a stopgap measure, what we could do, we could, and we'll talk about this briefly, is set up some supervised visitations for the father with the child that are supervised by the maternal grandmother, and that could, it could be a period of roughly, 30 days. I'm not sure how long it's going to take to get into things get going in Grace Harbor, and then have the motion of the temporary orders ruled upon. So in the two different parenting plans, Mr. Brogan suggested a 50-50 plan with exchange on Sundays, and then Ms. Edmondson Pena suggested a alternating weekends of Friday to Sunday was the proposed parenting plan. That was the one filed in May. Let me see if anything has changed with the more recent one filed in July 10th.
Your Honor, I have an amended proposed parenting plan.
Yeah, that's exactly what I just said.
Okay.
So the amended is basically professional supervised visitation, correct?
Yes, Your Honor.
And then there's no specific timeframes that you've laid out in your proposed temporary parenting plan.
I wanted to leave it open. I wanted Mr. Brogan to choose a day that he could fix for him so he can see his son. So it's not miscommunicated that I'm trying to make it to where he can't see his son. That's why I left the place open as well. He can choose a place here in Cowlitz County that fits his needs.
Mr. McNeil, from your client's vantage point, what would be a proposal for a stopgap visitation schedule?
93%. Yeah, I mean, Friday to Sunday would be fine. I just find it kind of ironic that Ms. Edmondson would initially propose something similar to that. And then after finding out that Mr. Brogan is in treatment and having clean UAs, then propose professional supervision. It's pretty disingenuous. So yeah, but and the short answer to the court's question is every other weekend, or every other, or just every weekend. Every weekend would be fine, since Ms. Edmondson is not working and she doesn't have any other obligations. I would say every weekend until we can get into Grace Harbor.
Okay.
Your Honor, if I may. The reason I stopped the visits was because I recently found on his social media that he was driving with speeds exceeding 100 miles per hour in Montesano, which is a town where the speed limit is 45 max. So that raised concern for me for him driving my child around. So that's why I wouldn't let him come pick up the child. After that, he has had supervised visitations here where my grandmother, who was a registered nurse, supervised, and it was not a very well visit from Mr. Brogan. So I would like a supervised. I think that's best for now until he has more sobriety under his belt, Your Honor.
Thanks. Give me just one moment, please. Mr. McNeil, do you have any suggestions as far as who does the transportation? Then we'll hear from Ms. Edmondson.
What do you guys want to do for transport?
We can meet halfway.
Okay. We could meet halfway, Your Honor. That'd be fine.
Is there a suggested midway point?
Grand Mound.
Grand Mound is approximately halfway.
Is there say a Minute Mart or some type of convenience store at that area? It's kind of public.
We met at Dutch Brothers last time.
Oh yeah, they had been meeting at a place called Dutch Brothers. It's a coffee stand in Grand Mound. That's where they had been doing exchanges before.
Okay, Ms. Edmondson.
Oh, well, I'm not sure what Mr. McNeil was just saying about we've met at the Dutch Brothers before. That's not true, but I am not okay with allowing Mr. Brogan to drive my child. I will drive my child all the way there, Your Honor. I do not need to meet him anywhere. I will provide full transportation for my child.
We will meet in town.
All right, thank you.
And I think then if she wants to come all the way to Montesano, that's great, Your Honor. And I think what we do is have the exchange at the Shell station in Montesano. They've got some very good cameras there. They've actually solved quite a few cases in Grace Harbor because the cameras are so good there. That way the exchanges would be in a camera and they would be in an area where there would be a record of it.
Ms. Edmondson.
Your Honor, I do not want my child with somebody who's driving over 100 miles an hour in a small, busy town. I don't think it's safe.
So Judge, we've got a video, the speedometer was not at 100 miles an hour. I don't
It
know
was
where.
110, Your Honor.
So
110.
just encourage the parties not to interrupt when everybody will have an opportunity to speak.
Yes,
Just
Your Honor. I
please let
apologize.
everybody, so even myself, don't interrupt me also when I'm speaking. It applies to everybody. Thanks.
Yes, Your Honor.
Mr. McNeil.
We've got a video indicating that it was not at 100 miles an hour. I mean, and again, Miss Edmondson forgets the fact that she had been smoking marijuana while she's driving, and she had also been drinking while she was driving. She also had some nieces that got in trouble while she was driving. So, you know, Miss Edmondson forgets that we've got some proof with the text messaging about some of this behavior that she's engaging in. So, Mr. Brogan is clean, he's sober, and he will fully comply with all of the court's orders, including obeying all the speed limit, having a license, having insurance, following the rules of the road, having a car seat. That's, I mean, everybody should be doing that anyways. But if the court wants to interlineate that and that would satisfy Ms. Edmondson, we can put that in an order and that will not be a problem.
Okay. Okay, the bench order for today is until Grace Harbor Superior Court rules and issues a temporary parenting plan, the following residential schedule shall be followed. Friday, 5 p.m. to Sunday, 5 p.m., father's residential time. Primary custody is mother. The exchange at the Montesano, Washington Shell gas station, and the mother shall provide all transportation. So with that, I'll finish the order. Well, actually, I don't think I will finish the order appointing guardian ad litem because that guardian ad litem is going to be supplied if the court in Grace Harbor so chooses. So I'm pulling back that ruling related to the guardian ad litem. So I'm scuttling all of that, and then at Grace Harbor, that same motion can be brought and can be ruled upon by the court there. Any final questions, Mr. McNeil or Ms. Edmondson?
I don't have any other questions, Your Honor. Thank you for your time this morning. Thank you, Ms. Russell. Thank you, Ms. Edmondson.
Ms. Edmondson?
Yes, Your Honor. When does visitation start?
This week.
Okay, thank you.
Okay. If either party needs a copy, you can contact the clerk and get a copy of that bench order today. And then just one final thing also is that on that bench order, I'm going to also just make mention that the court granted the motion to change venue, so that I don't think we need a separate order, so we can just include it all in that one if everybody's okay with that.
Your Honor, I have one final question.
Go ahead.
It is every other weekend, correct?
It's weekly. It's weekly until the Grace Harbor Superior Court makes its ruling.
So I don't get a weekend with my child, Your Honor?
Not until the temporary parenting plan in Grace Harbor is decided upon.
Okay, and this is for 30 days?
Well, there's no specified time frame on it. The specified time frame is until the Grace Harbor Superior Court issues a ruling on the temporary parenting plan.
Okay, Your Honor. And his mom is to be there to supervise, correct?
Yes, and I'll just put that there. Thank you for that reminder. I'll just put shall be supervised by maternal grandmother.
At their house, at their residence, Your Honor, is that correct?
They can go anywhere they want as long as it's there supervised.
So no out of state though, Your Honor?
I think that's reasonable.
Okay. Thank you.
Just adding that. Let me just review that the final notations on the order. So it says the court grants the motion to change venue to Grace Harbor. Until Grace Harbor Superior Court rules and issues a temporary parenting plan, the following residential schedule shall be followed. Friday, 5 p.m., Sunday, 5 p.m. for the father shall be supervised by maternal grandmother, not to be removed from Washington. Primary custody is mother. Exchange at the Montesano Shell gas station. Mother shall provide all transportation. I think that covers everything for today. Okay. All right. Thanks, everybody. Appreciate your help. Okay.
Thank you, Your Honor.
All right, Mr. Connor, you're present here today.
Yes.
All right, very good. All right, so this is your motion, Mr. Connor, for appointment of a guardian ad litem. Is that correct?
Yeah.
All right. So as far as notice, Ms. Camarena, did you receive a copy of that motion?
Yes.
You did. Okay. And then, Mr. Connor, did you file a confirmation or declaration of service that you served that
Proof of
document?
service, yes,
When did you file that?
this morning.
Okay, that's why I asked. So just so you know, just when filing does not happen instantaneously. Generally, there's like 2 to 3 day lag from the time the clerk's office receives it until it gets processed, and I see it in my scanned version here. So you're comfortable then proceeding today because you did receive notice of the motion?
Yeah.
Okay. And then as far as your the motion, let me just pull that up here. I just need a little information from the parties related to finances, and the information I have related to that comes from the state and the employment security data uh, agency, where they indicate that Mr. Connor, your gross monthly wage is about 5,900 and net is about 4,900, and Ms. Camarena, your gross is about 5,500 and your net's about 4,670. The parties agree that that's roughly accurate, Mr. Connor?
I've been moved to part-time as an employee, but when I'm working full-time, that's accurate. Yes.
Okay. Is it a temporary part-time, or
Yes.
you anticipate going back full-time at some point?
Yes.
How far in the future?
Once my summer school's over, I switched to day shift, and that interrupted me working full-time while I was in summer school. So the beginning of September.
Okay, you'll be back to full-time.
Yeah.
All right. Ms. Camarena, what's your viewpoint as far as the finances?
I had a job change, so my income is probably about maybe $500 to $600 less each
Okay.
month.
Okay. And do you have any opposition to the motion to appoint a guardian ad litem?
I necessarily don't, but I would request that Stephen, since he's requesting it, that if we are financially responsible for it, that he is responsible for it, since he's wanting to have it.
Okay. So let's go to the next step. I'll ask the clerk again to what we talked about in that earlier case where I appointed a guardian ad litem, but then I revoked it. But there was 3 names provided to each of you, and if you want to strike somebody, you can. And if you don't, neither party strikes anybody, then it'll just be the first person on the list that I appoint. So let's go through that process again. Yeah, I think we leave the same order because I didn't really appoint her in the end. Yeah.
So the next 3 names are Heather Call, Beth Fellows, and Amy Turnbull.
Mr. Connor, any of those individuals you would like to strike?
The first one, Heather Call.
Okay. Ms. Camarena, any individuals you'd like to strike?
I don't have any preference.
Okay, so I'll appoint Beth Fellows as the guardian ad litem. And as far as the finances related to that, I think what I'll do, I'll assign 55% to be paid by Mr. Connor and 45% to be paid by Ms. Camarena, based on the representations of a slight decrease of pay and that you'll be going back to full-time in September. So what'll happen is that Ms. Fellows will reach out to you, both of you, and based on the information that you've used in your pleadings. So any pleadings, that's the contact information that she'll use to contact you. Please be responsive to her emails and communications. That'll speed up the process a lot. My sense is that both of you will be on top of things and provide good follow through related to that.
Your Honor, Your Honor, this is
Yes, Ms.
Beth
Fellows.
Fellows, and I am on the line.
Welcome. Thanks for being here.
Thank you.
All right. And just to the scope of that investigation, Mr. Connor, can you tell me what you're hoping the guardian ad litem will investigate? There's a whole list of things that could be. As a general idea, the guardian ad litem looks at the best interest of the children. If there's any concerns about parent inabilities, abandonment, criminal history, domestic violence, mental health, physical health, sexual abuse, substance abuse, you can specify those.
Yeah, I have concerns about the physical safety of the children. Rocio and I fundamentally disagree on what things are, needs for the children as far as safety goes, specifically restriction to animals and the freedom to be around animals, and other things like, as you've read, certain psychological things that I'm worried about, exposure to things that shouldn't be discussed or brought up to them.
Ms. Camarena, any items that you're interested the guardian ad litem would explore?
From my experience of the situation that's happening, there's a lot that I disagree with. My relationship with Stephen was a pretty negative one, a very psychologically abusive one, a lot of manipulation that was involved. And the situation that Stephen is talking about with our youngest is that my aunt started caring for Nico at the start of the school year, and he was 2, turning 3, And within that span of maybe a few months, he got scratched by a cat. He's a toddler. And I know that the scratch was very close to his eye, and that's concerning. But nevertheless, Stephen reached out to me expressing concerns about that. And I get that a cat scratch can be, especially since it was close to the eye, that's scary that it happened. But he was then saying, because Nico got scratched by a cat, a toddler getting scratched by a cat, therefore signifies that he's being neglected. He's not being well taken care of because of a cat scratch. And I know that he got scratched again the following week. In an entire year that he has been cared for by my aunt, that's the only times he's been scratched by a cat. And again, he's a toddler. He's 3 now.
Okay, so kind of what I'm focusing on is just this appointment of the guardian ad litem. So it's kind of broad strokes of what the guardian ad litem would be investigating. So I indicated, all issues that could affect the safety of the children, all issues related to making a parenting plan. So I think that'll address those issues. So I appreciate that input from both of you. So let me just get the correct names of the children in here. The time frames, there's 3 dates that I'm going to set. September 4th is just going to be a simple review to make sure you've had communication with the guardian ad litem from both of you. That'll be on September 4th. And then as far as a final guardian ad litem report, Ms. Fellows, do you have any input on a timing of that?
Looking at my calendar, we're in August, September, October, November. I would say mid-November. So maybe November 20th.
All right, just so each of you are aware that what this order states, it indicates that a guardian ad litem is appointed, and it's Ms. Fellows, and it involves the 2 children, that she will investigate all issues related to making a parenting plan for the children, including any of the issues listed below, and the guardian ad litem shall include recommendations in the reports, and some of the issues to more specific is just interaction with animals and any issues that affect safety of the children, in addition to the parenting plan issues. So that'll all be covered. And we set the 30-day review for September 4th at 9 o'clock. And then the final review will be on November 20th at 9 o'clock. Those are all both Wednesdays. And then the fees, 55% will be paid by Mr. Connor, 45% will be paid by Ms. Camarena. And then I signed that order. So any questions, Mr. Connor? No. Ms. Camarena?
No, September 4th.
September 4, correct?
And November 20th.
Yes, yes. So that order of appointment will be filed. If either party needs a copy of that, you can check with the clerk's office and get a copy. Okay. All right. Any final items, Mr. Connor?
No, sir.
Ms. Camarena?
I filed a motion for contempt because Stephen isn't following the parenting plan, so I'd like to address that as well if we can.
So when did you file that?
Within the past month, I believe.
Looks like July 3rd, and it looks like the order to show cause was set for July 31st. And let's see what happened on July 31st.
It got moved to the
Court addresses the motion and insufficient time for service. Court sets the matter over to August 7th. And then Mr. Connor, did you file a response to that?
No, I didn't.
Okay, why not?
I thought I was just supposed to appear and we were going to discuss.
Okay. So the motion related to an allegation from June 27th to June 29th of not having supervisors present during that visitation.
Your
So do you want to, that's your allegation, right?
Yes.
I think it's pretty clear on its face that the parenting plan required that, and there's indication that did not happen. So,
Yes, and it has not.
okay.
Since late July.
Okay, so the pattern's continued. Okay, Mr. Connor.
We had been in agreement since the beginning of 2024 that I was allowed to watch them at my apartment. Her telling me that I needed supervision was in a response to me advocating for their safety. But we had been in complete agreement that it was okay and safe for them to be watched by me unsupervised since the beginning of 2024.
Was that agreement? Is there any written?
There's text message proof between she and I. And I also think that since she hasn't filed contempt in the past 7 months for me watching them in that exact same situation, it would show that we had an agreement that it was okay.
Right.
Because it's been that way every time I've had them. She was out of the country, Your Honor, for 14 days, and I was still watching them unsupervised. And then it was upon her return that she started demanding that I revert to the old ways we would do things.
I guess my question, it puts us in a bit of a difficult situation, that the indication is that there's a temporary parenting plan in August of 2022 that requires supervised visitation. Then there's an indication that there was an agreement in January of 2024 in writing that there wouldn't be supervision. I don't have any of those text messages. There's an indication that those text messages are available. If they're available, I want to see them. So if you want to submit those, Mr. Connor, we'll set this over either 1 or 2 weeks, depending on your schedules. I recognize coming back to court is probably not your favorite thing to do. But I think it's important to see what the evidence shows, and if it's available, we should be able to look at it. So today we're the 7th. We could either come back on the 14th or the 21st.
Can I also respond? I can confirm we did agree to that.
Oh, okay.
The reason why I decided to go back to the parenting plan was because the day before I left for my trip leaving the country, he served me with a restraining order because, again, he had mentioned that our kid got scratched by a cat, therefore he's being abused and neglected. And because I didn't agree with him on that, he filed a restraining order to me, served me with a restraining order because me not agreeing with what he's saying is harassment, and it's dismissing him. And so I had to leave the next day out of the country, and I was gone for 12 days. And when that, again, our relationship was not a healthy one, and I see this as coercive tactics, and it would give me time to reflect on it. And this seems very disingenuous. It seems very manipulative. And then also with the documents that he's filed explaining his reasons why he's concerned about my ability as a parent, it's all of just trying to make me look like I am a mentally unstable person. Very, again, just manipulative. And he's using our toddler getting scratched by a cat as me being a neglectful parent. I see it's disingenuous. And that's why I wanted to go back to the parenting plan, because this doesn't show me someone who's emotionally mature. This shows me someone who is engaging in past negative, abusive tactics and behaviors.
So you mentioned that there was initial agreement in January of 2024 to deviate from the parenting plan. And was there a written agreement of revocation of the January agreement?
We didn't have an official written agreement, but we do have text conversations with an agreement of that, and a verbal agreement. But we don't have anything formal. And it was when I came back from my trip in late July, where I explained to him and his mom of why I wanted to go back to the parenting plan and my reasonings for it, and that if the parenting plan wasn't followed, I would be filing for contempt, and that he is more than happy to, if he wants to change the parenting plan, then he can do that through the court system. But because of his behaviors, I'm not going to be bullied.
Okay. I feel like I'm shooting from the hip. There's a bunch of text messages and information that y'all have. So if I were to issue a ruling, I don't think it would be as solid as I would like it to be. So let's go back and talk about dates, either the 14th or the 21st of August, which would work better for the parties.
So you said 14th to the 21st?
Yes, probably the 21st. And I'll tell you why, just as far as gathering that information, getting it served upon the other party. And then if any party wanted to reply to what the other party had submitted, that would allow enough time if we allowed for 2 weeks, coming back on August 21st. Mr. Connor,
yeah, let's 21st works for me.
that works. Okay, 9 a.m. Mr. Connor?
Yes, sir.
Okay, so both of you, so if Mr. Connor, Ms. Camarena submitted her motion, her written motion, and if you want to supply something in a written declaration in response with any attachments, you can do that. Make sure you file it and serve a copy to her. And then Ms. Camarena, if you want to add any additional information, including text messages, explanations, you do the same, file the declaration with the court and serve a copy to Mr. Connor. And then we'll be on the 21st to address the motion for contempt. Okay. Any other issues before we break?
Can we set the expectation that the parenting plan will be followed then until we do have our court hearing?
Sure. So that's a common issue. If parties, I recognize life needs to be flexible with children. So kind of the parenting plan is baseline. If the parties can't agree, the parenting plan controls. If the parties agree, then there's flexibility built in by virtue of your agreement. But if the parties don't agree, the parenting plan is what controls. Okay, we'll see you on the 21st.
So the expectation is that I have to have supervised visitations. when I
The
have
expectation
children.
is that the August 12th, 2022 parenting plan controls all residential time.
Okay.
So you can make reference to that and just need to follow that.
Okie dokie.
Thanks.
Thank
I'll
you,
ask
Your
if
Honor.
Eric Solis is on
Thank
the
you.
line. Next, I have Eric and Cagney Solis. If you're on the line, please state your name.
Good morning. This is Cagney. I'm here.
All right, welcome to you, Ms. Solis. And Eric Solis, if you are on the line, I haven't been able to hear you, so please unmute and then state your name so I know you're present. Eric Solis? Mr. Solis, are you on the line? All right, there's no response. We're here for a presentation from the July 10th hearing. And let me just find the documents related to the presentation. Ms. Solis, you submitted a proposed order to bring the mortgage current or sell the home, appraise the home, and to list the home with a realtor. One thing I had a question about was the award of attorney fees in the amount of $1,000. Was that something that the court specifically ruled upon at the July 10th hearing?
My attorney had said that it was. I was not 100% sure on that. So she just added it on there.
Okay. So looking at the July 10th, I'm looking at the minutes. The indication is that the court granted the motion to allow respondent, Ms. Solis, to list the home for sale, grants $5,000 to each party for moving expenses after the sale of the home, remaining proceeds to be held in trust. Court advises Ms. Solis to prepare and present the order. Court sets the matter to July 24th at 9 a.m. So there's no explicit indication that attorney fees were awarded. And that's a pretty common thing that is included in these types of orders, but sometimes things can be missed. But you indicated you weren't 100% sure that was actually ordered.
Yeah,
right?
she said that she was listening. So I go through her assistant and said that it was awarded for $1,000. And the reason why is because he had originally started this whole divorce debacle. I had a lot of domestic violence stuff, but he had started this. I did all the paperwork for his attorney. And then he never submitted any of the documents. And I spent all this money from my attorney to redo all the paperwork, and he's still not being compliant with it. And I think that's where the $1,000 came in.
Okay. Did you submit or share with Mr. Solis a copy of this proposed order that we're talking about today?
Yes, he got it on the 23rd by hand, and then it was also emailed to him.
And when did you email it to him?
On the 23rd.
All right.
The day that it was submitted to court.
I've signed off on your order with the absence of Mr. Solis objecting. I'll follow the presented order, and I've signed off on it, so it's signed. Any questions, Ms. McAdams? Now, is that correct?
That is it. Thank you, Your Honor.
All right, thank you. We're here on Ms. McAdams' motion for a restraining order. And one thing I wanted to check with you, Ms. McAdams, is related to service of documents of your motion and the like upon Mr. Woods. Did you serve him copies of that information?
I gave them to the sheriff's office, so they were supposed to have served them.
Okay. And have you received any communication from the sheriff's office to see if they were actually able to serve him those documents?
No, I haven't. Normally when I have them served through them, because I just don't want to deal with it myself, I normally don't get papers for like a month.
So what I'm looking at, just so you're aware what I'm looking at, the temporary order was issued on July 17th. And generally, if there is a return of service, the sheriff will file that document. It's a return of service or declaration of service. They'll say on such and such a date, I either served or didn't serve, I couldn't find. So I don't have that return of service filed by the sheriff's office. I'll ask Mr. Woods or Mr. Wood, did you receive a copy of the motion for restraining order and the copy of the temporary restraining order?
No, Your Honor.
Okay. All right. And then Ms. McAdams, are you interested in the order continuing and making an effort to serve Mr. Wood?
Yeah, I wanted to continue it. I need it for my safety, and I'll try to contact the sheriff's office today.
Okay. All right. So where that puts us is that there was a temporary motion that was issued based on what they call ex parte, meaning only one side's voice was heard. And so in order for that for consideration of whether that temporary order becomes a permanent order, Mr. Wood needs to be served with what those documents, so he knows what Ms. McAdams is saying, what the allegations are, so he has an opportunity to respond to that. So since the looks like Judge Basher on July 16th made a finding that that temporary order should be in place, I'm going to continue that for a period of 2 weeks, and to see if that service can be effectuated during that time frame. Those same restraints would be in place until we come back and have a full hearing on that order. Do you have any questions on that, Mr. Wood?
I just haven't seen my son in almost a year now. Everything was fine for the first 2 months of the divorce, and then all of a sudden she just wouldn't let me see him anymore. And I've never done anything wrong to her. I've never been violent to her, other than before the divorce on a drunken stupor when I was in Alaska, when I knew she was cheating on me. I said some pretty outlandish things, but I haven't made any kind of a contact with her. I haven't harassed her or my son in any way, shape, or form. I just stay clear. And I don't understand why she's trying to keep my son from me when I've done nothing wrong, done nothing violent, nothing criminal, nothing at all.
Okay. So I appreciate that. And what'll happen is that you'll have a full opportunity to respond in writing with a declaration and any information that you want to share in response to the allegations by Ms. McAdams.
Okay.
And then you can submit that to the court and then serve a copy upon her. And so what we'll do is I'll reissue that temporary order that was issued on the 17th of July. So that's still in effect until the 2 week time period. And let me just confirm that both of you would be available on August 21st, which is a Wednesday at 9. Ms. McAdams, as a petitioner, are you available?
I can make myself available. I'm gonna have to miss work again, but
Okay, that'll be at 9 a.m. And then Mr. Wood, are you available on August 21 at 9?
Yes.
Okay.
and then can I say something real quick?
Just one moment. Let me just take a moment to finalize this order and then
Okay.
get it from you. And Mr. Wood, which city or do you live in, as far as like service, is it a sheriff's office? Do you live in unincorporated, or you live between one of the incorporated cities?
I live in Longview, Washington.
You're Longview, okay.
Yeah, right by Dairy Queen.
Okay. But there's just a place here on the order that asked me which law enforcement agency is going to do the serving.
I think it was LPD that served the first one a year ago.
Okay. Yeah, so we'll put that down here. And Mr. Wood, you do have the option also, if you want to contact Longview Police and say, hey, if you want to swing by and drop those papers off and make yourself available, that might make it easier. And then that way you know what she's saying, and then you can respond to what she has to say.
Your Honor, I didn't even know I had that there was a hearing today. I just happened to call because I knew the restraining order was expiring soon, and I was getting anxious to possibly see my son, and I wanted to check it out. And I called the clerk, and she's like, well, you actually have court today.
Okay. All right, thanks. Ms. McAdams, so at this point, the temporary restraining order that issued on July 17, 2024 is in effect. It continues until the next hearing on the 21st at 9 a.m.
Okay.
So then if your question relates to any of that, hopefully that answers the questions. Otherwise, I'd be terminating the case review today and just see everybody on the 21st.
Well, it was just in regards to him saying he doesn't see his son.
Yeah, we're not going to talk about that today.
Yeah,
but of a different hearing.
address.
We don't need to address that today.
Okay. Well, the address that I have it sent to, if it's not the correct one, that could be why he hasn't been served yet either.
Could you repeat that, please?
The address that I had the court or the sheriff's office serve him at, if he's not living at that address, then that could be why. So how would I know if he's still living at that address?
So if you do you have another address where he may be?
No.
Okay.
All right. So and certainly, Ms. McAdams, you can check with the Longview Police Department, coordinate with them. So we'll see everybody on the 21st of August. Mr. Franklin, thanks.
All
I assume
right.
you're Mr. Franklin. All right, thank you. Okay, welcome. And is Rachel Franklin present? Ms. Franklin, if you're here, please unmute and state your name or say good morning so we know that you're here. All right, there's no response from Ms. Franklin. Mr. Franklin is here. This is the state's motion for child support, and it looks like service was effectuated via post office sent on June 21st. Mr. Franklin, did you receive the pleadings and copies of papers from the state?
Yes, Your Honor.
Okay. And just checking with you, sometimes people will file a response, a written response into any party's motion. Did you file anything in response?
No, I didn't know I could, or I was surprised to get this, to be honest with you. Because
Okay.
I am trying to get divorced
Mhm.
and a custody thing going here. I had her served June 6th, and she refuses to communicate with me in any way, shape, or form. And so I'm not sure, from what I read, if I read it correctly, she has 90 days to respond,
Mhm.
which will end here pretty soon. And so then I can do a default thing, apparently, so.
Mhm.
I just don't know really what to do. I'm just here because I have a court date for this, so I want to try and miss it.
Great. Yeah, I'm glad you're here. So I'll turn the time to Miss Looney. She can explain what her position is on behalf of her client. And then if you have any thoughts, I'm happy to hear from you about that too. Miss Looney?
Thank you, Your Honor. So the state did make a motion for temporary child support. We did see the divorce proceedings were begun, but we are looking at requesting a temporary order in the meantime because all three children are currently receiving TANF benefits with Mr. Franklin. So we are requesting an order be put in place today. We did impute Ms. Franklin's wages at the current minimum wage of 35 hours per week, which gave a net monthly income of $22.10. Mr. Franklin is currently receiving SSDI benefits in the amount of $714. So we use that as his actual income for the purposes of calculating child support. We have a resulting payment of $641 from Ms. Franklin to Mr. Franklin for all three children, which is about $213 per child. TANF benefits began in May of 2024. So we're requesting that be the start date based on the state's or the prosecutor's ability under RCW 7420 to request reimbursement of all money paid on behalf of children by the state for benefits, as well as the fact that any parent receiving TANF subrogates their right to receive the support to the state and allows that to be collected for back support as well.
Okay, thank you. All right, Mr. Franklin, what's your take on what Ms. Looney said? What do you understand from what Ms. Looney just stated?
Basically, you're going to make her pay the child support, and it's going to go back to the state to help repay the TANF or pay for the TANF.
Ms. Looney, do you want to clarify that question?
I'm not sure I heard all of it. I did turn up my volume. It's difficult to hear, but I believe he was asking if we were requesting to collect child support as reimbursement for the state. Is that accurate?
I think, Mr. Franklin, and correct me if I'm wrong, he stated that basically the state wants Ms. Franklin to pay child support of $641 a month, and that would be paid to Mr. Franklin for the support of the children.
Yes.
Okay.
Your Honor, it will go to the registry, the state registry for child support. If the amount paid is more than his TANF benefits, he will get a pass-through payment. If it's more than his TANF payments for 3 consecutive months, his TANF will end, and then he will just receive the support directly through the registry. DCS will pass those payments on to him.
That makes sense?
I understand that, yes.
Okay.
That's what I was actually saying.
Okay, perfect.
I didn't word it correctly, I guess.
She's had probably a little more practice than all of us.
But that's what I was preferring to, yes.
Okay. So do you have any concerns with the paperwork or any questions or anything that the state is asking for?
No.
Okay. I believe, some proposed orders, Ms. Looney, that you submitted.
Yes, Your Honor, you should. We sent those over on the 25th of July.
I have those here. So this should be a copy that Mr. Franklin also received. And this is it's a child support order. It looks like that. Okay. Where it goes through and lists the incomes that were stated earlier in the hearing, the $640 transfer payment. I'll go ahead and sign that. Okay, that order is signed. Ms. Looney, any additional items on your end?
No, Your Honor.
Mr. Franklin, any questions or any items on your end related to the child support motion?
No, sir.
Okay. All right. If either party needs a copy of that for your records, you can check with the clerk's office and get a copy.
All right, thank you for your time.
Great. Thanks.
Thank you, Your Honor.
All right. Additional cases, Ms. Looney?
I do not have any additional cases I need to be present for today. Your Honor.
Pronunciation
Thank
of
you.
your last name?
Chittister.
Chittister. Okay. Thank you. And is James Haynes on the line with us today? James Haynes. Okay. There's not a response. I want to check with you, Ms. Chittister, related to service of your motion and the paperwork that you had filed. Did you serve a copy of those documents to Mr. Haynes?
Serve him. I hate to have the sheriff serve him, and they have not been able to serve him. I was just informed by him himself 2 weekends ago that he is actually back to driving truck,
Okay.
being a transport driver, and he is actually on his way to Indiana right now.
Okay.
To pick up a load. So he's not even in state for me to serve him.
Right. So one of the kind of the bedrock principles of any court proceedings is the notice and the opportunity to be heard. You've heard due process often. So I know what you're wanting. You filed some motions, you filed some declarations and the like, and I don't know what his position is related to that. And that's why there's that requirement for the service of those documents.
Yes, I completely understand.
Sure. Okay, good. So with today's hearing, I'm not in a position to move forward. So it sounds like I did see that the sheriffs, they said, hey, we tried to find him, but we couldn't before the time period ended, so they couldn't serve him. And I don't know, did you get a copy of that?
Yeah, I did.
Okay. So what we can do is two things. One is if you have kind of a general idea when you think he may be back and could be served, we could set it to a time thereafter, allowing him time to respond and serve you with his responses. Or we could just leave it open, strike today's hearing, and then you could note it up once he's been served with the documents. Generally, that's a little better because it's known, right? If we know that if he has been served, okay, he's been served.
Right.
Now that he's been served, then the date can be set for a hearing.
Let's do that one.
The
I
latter.
will get him served and go from there.
Okay. Yeah. So once you have service, then you can note it up on the docket for a hearing, and then we can hear from both parties and get things figured out.
Sounds great.
Great. Thank you.
Thank you.
Looks like both parties are present. Give you a moment to get settled. Oh, okay. Okay, we have, I'm assuming that you're Katrina Vorst. Okay, very good. Welcome to you. And I'm assuming that you're Jack Carnahan.
Yes.
Okay, welcome to you, sir. All right, we're here on Ms. Vorst's motion for a restraining order. I'll give you a moment, sorry. I wasn't sure if you're going to stand or sit. Looks like you're going to sit.
Sitting.
Perfect, good. All right, so we're here on Ms. Vorst's motion for a restraining order. It looks like there's a temporary order that was issued on July 18th, 2024. And that was, let me just pull that up. Let's see, that was issued on, like I said, on July 18th, and that was by Judge Hahn. And they set it for a hearing date for today. And Mr. Carnahan, did you receive a copy of that temporary restraining order?
I got 4 pages just stating that she had filed for it.
Okay.
And
did it tell you the date to come to court?
Yes, it did.
Okay. And so that's today, August 7th. And and it looks like there's a child is it Justin?
Jessica.
I have
Jessica. Okay. I don't disagree with you on that one. Okay, so it's Jessica who's 2. All right. And then so Ms. Vorst, just checking with you, are you still interested in that temporary order becoming a permanent order?
Okay, I'm just gonna kind of explain because I feel that my child got put in danger when he lost communication and took her up to a drug house and didn't communicate, which is why the restraining order was granted. I want him to see our daughter. She loves him, she asked, but I do not want her to be up at that house. I do not want her to be in the presence of drugs, and I want him to be in compliance with his SUD treatment.
Okay.
Which is in the parenting plan. I just have to figure out how to serve him.
Okay. And then Mr. Carnahan, what's your position related to that temporary order becoming a more permanent order? Are you agreeing with it or objecting to it?
Oh, I object to it.
Okay.
Definitely object to it.
Oftentimes, so what I know about this case is that there was a motion filed by Ms. Vorst. It outlines her concerns. Did you receive a copy of that document?
No, I did not.
So it's a document. It says motion for immediate restraining order. You didn't get that. You just got a copy of the actual order.
Yeah.
Okay. All right. So in that motion, Ms. Vorst outlines some concerns that she has related to the issues in your child. And it's about a page and a quarter where she kind of describes that in single spaced lines. So generally, I think what I'd like to do in these cases is that what we know is that Ms. Vorse has a temporary order that's allowing a restraint upon Mr. Carnahan and visits with the child. And I know what your concerns are. You know what your concerns are. Mr. Carnahan doesn't know what your concerns are, and he doesn't. Yeah, I think he needs to have an opportunity to read what your concerns are and then have his response to that. And so I know what your side of the story is. And generally what we do in these types of cases that we generally continue it roughly for 2 weeks. The temporary order that was issued continues for that 2-week period. Then you would serve a copy to Mr. Carnahan. Mr. Carnahan would know what you're saying, and then you can write a response, what your feelings and thoughts are about the situation, submit it to the court, and send a copy to Ms. Vorse. So that's what I'm inclined to do, and I'll hear if any party has any concerns with that proposal.
The last known address I have for him is, and that's not a safe place for me to go. And so how do I go about having him served?
Well, there's a couple different ways you can do it.
Because I don't even know if that's his address anymore.
Yeah. As far as, is there an address, Mr. Carnahan, that would?
No, that's a good address.
Okay, so you can be served there?
Yeah.
Okay, and then since Ms. Vorse, anytime parties aren't allowed to serve other parties, so you have to have a third party do the service, and that can be accomplished through law enforcement or through a third party.
Okay, I can have a third party serve him as long as I ensure that they're not going to be in harm serving him paperwork there.
Yeah, a third party can serve the paperwork, and obviously that if parties have concerns, they can contact law enforcement about any concerns related to that. So that's kind of where we're at. Mr. Carnahan, do you have any questions about kind of the next steps? The next steps will be one would be, I don't know, do you have a copy of your pleadings?
I have the copy of the page and a quarter that I wrote explaining my, you know what I mean? I have that copy because I typed it up.
Okay.
And actually, no, that's a lie. I do have copies of everything I filed with the courts to have him served. I just wasn't sure about how to go about it.
If you have not. So
can I do certified mail?
It has to be in person.
Okay. I can have somebody drive up.
So if you have that information, I don't know, Mr. Carnahan, are you in a position to receive that today, and then you can read it and get started on your response?
Yeah.
I don't have a way up there, but I do have it out. He knows where I'm located at. I can have a third party give it to him there.
Okay. I was thinking that you had it here today.
I don't have it with me now. I have it in my room now.
Okay. All right. So you all can work on the service issue to make sure that you get your information to Mr. Carnahan, and then Mr. Carnahan, once you get that information, then you'll need to make sure you send a copy to Ms. Vorse, and it has to be a third party, can't be yourself. And generally you can use mail.
You are speaking of my response, right?
I am.
Okay.
I am. So let me just take a moment to reissue that temporary order until we come back on the 21st. Where we'll have everybody's information before me, and I'll have read that, so I know what everybody's thinking.
Well, I have gotten his response by the 21st, if he writes one.
Yeah, there's some local rules. If you want to look at, if you go to the Cowlitz County Superior Court website, there's a local rule. There's a series of blue boxes. One of them says rules, RULES. Click on that and then look for rule number 88. That'll tell you the general timeframes as far as responses of when each party has to file their respective declarations. So let me take a moment just to reissue that order and set the new date. And just confirming that you're both available on August 21st at 9 a.m., Mr. Carnahan?
Yeah, I will be.
Yes.
Okay.
I have one other question, if I'm allowed.
Sure. Bear with me one moment. Let me finish this and I'll hear from you.
Yeah.
All right. So let me just review this and I'll hear from you. So this is an extension of the immediate restraining order and hearing notice. So what it says is that this order extends the immediate restraining order. That's that 4-page document that you had that was issued on July 18th, and the court is going to reset the matter to hear from both parties on August 21st at 9 a.m. in this courtroom. There's no need to serve a copy of this document on Mr. Carnahan because he's hearing about it. And if you want to come up and take a look at it and read through it, I'm fine with that too.
I haven't found them.
Okay. And so then we'll see everybody on the 21st. Ms. Forrest?
Yes, I was in the process of filing for the appointment of a guardian ad litem. Can I file that and have that addressed at the same time with at the next court date?
Potentially, you'll have to take a look at the timeframes as far as service and the like. That potentially it could be heard on that date if it fits within the timeframes.
Okay,
And you can check on that local rule 88.
okay, thank you.
Okay, any final questions, issues? Okay, thanks. Baker and Brandon Connolly.
It's Giles.
It's Giles. Thank you.
Yeah.
Appreciate that. Make that. Just so you know why that happens is that when the case is filed, the case name is inputted into the system and then it forever stays that way. When I'm just looking on the outside of the file, so I apologize for that.
From when I got divorced in like 2011 or 2010.
Pardon me?
I got divorced in like 2011 or 2010, and that was my last name when I got divorced.
Oh, okay. Brandon Connolly, are you on the line? Mr. Connolly, I can see that you're part of the Zoom call. Can you hear me? So, Mr. Connolly, if you're speaking, I cannot hear you. So please make sure you're unmuted and state your name. All right, Ms. Giles, I can see Mr. Connolly in the Zoom call, and I saw him kind of coming and going a couple of times. I had to admit him a couple of times earlier in the docket. So he's technically here, but he's not responsive. So what I'd like to do is call one case and then return to your case to see if he comes back to the Zoom call.
Sure.
Okay, I appreciate your patience. Thank you. Mackenzie Goebel, are you on the line today?
I am.
Okay, welcome to you, Ms. Goebel.
Thank you.
And then Ian Goebel, are you on the line?
Yes, I am.
All right, great. Welcome to you, Mr. Goebel. All right, we're on today for, it looks like a presentation. There was a oral ruling on July 10th of 2024. Indication was that Ms. Goebel was going to be drafting that order, and let me double check with Ms. Goebel. Did you submit a proposed draft of that order?
I did, with a few changes that we do agree on.
Did you submit it to the court?
Yes.
Okay. All right, so this was handed to me just during the middle of the docket, so I haven't reviewed it. Mr. Goebel, did you get a copy of that proposed order?
Yes, Your Honor, I did.
And do you feel that it accurately reflects what the court ordered on July 10th?
It does, but like Ms. Goebel said, there are a couple of changes that we had talked about and agree on in there.
Okay. All right, and so you've reviewed those changes and you feel comfortable with those and you agree on those?
Yes, I have.
Do you feel like you're being pressured into agreeing to those changes?
No, I'm not.
Okay, and you're making that of your full volition and freedom and choice?
Yes, sir, I am.
Okay, so so I have that here. Let me just take a quick look over at things. Okay. I've looked over that. I'm fine with that. Do both parties feel comfortable if I were to sign off on that parenting plan?
Yes, Your Honor.
Mr. Goebel?
Yes, Your Honor.
All right, very good. I'll take just a brief moment to sign that. Okay, I've signed off on that parenting plan, and that'll be filed with the court clerk. If any party needs a copy of it, you can certainly check with the clerk and get a copy. Does any party have any questions?
No, Your Honor.
Mr. Goebel?
No, I do not.
All right, that'll conclude the matter for today. Thank you very much.
Sorry. Thank you.
Thank you.
Okay. All right. So we have Mr. Connolly. You can hear me okay?
Yeah. Sorry about that.
Okay. It's good to have you here. And Ms. Giles, you can still hear me, correct?
Yes.
All right. Very good. All right. So we're here on Mr. Connolly's motion for contempt. And I wanted to just double check with Ms. Giles. Giles or Giles?
Giles.
So a hard G.
Yes.
Giles. Okay. Thanks. So related to whether you received a copy of the motion for contempt filed by Mr. Connolly and a copy of the order to show cause.
Haven't received anything.
Okay. So let me circle back to you, Mr. Connolly. I saw that there was a declaration of service. There was also an order related to service that allowed you to serve via, I believe, by U.S. Postal Service, correct?
Yeah. Yeah, I wasn't able to serve her this time because she was actually in Texas. So I wasn't sure when she got back. I didn't even know she was back. So that's why I have not had a chance to serve her.
Okay. Yeah, that was the one thing that I saw is that I wanted to touch base with the parties on this also because the order regarding service allows Mr. Connolly to serve Ms. Giles at the address in Vancouver. And it says that the requesting party may serve the summons and the petition in the case by mail at that Vancouver address. And that's on that's your address.
Yes.
And then is it apartment number? Does it have numbers and alphabetical?
Two letters and a number. So
okay, all right. I wasn't quite sure. Okay. So that allows for that service to occur. And then for today's motion hearing, Mr. Connolly, you're indicating that you haven't been able to get that information to Ms. Giles at this point.
Yeah. I'm going to ask for a continuance for a few weeks so I can get her served.
Okay. All right. So I think that would be appropriate. So what Ms. Giles, what Mr. Connolly has indicated is that there's that motion for a contempt hearing and an order for a contempt hearing to occur. And he needs to get that to you. So if he mails it to you at that Vancouver address, will you get that?
Yes, I will. I would just like to ask like what it states in there.
Yeah, that's important consideration. What's going to happen is that he'll send you a copy of the motion for contempt.
No, I already know about that. I was just wondering like what he's saying the contempt is for because.
Right. And that's what I was saying is that the motion will cover that. It will talk. Basically, the allegation is that there's no visitation on June 7th through the 9th, June 14th through the 16th, and June 21st through the 23rd. That's the allegations listed in the motion, and that's what the order for the contempt hearing is about.
Can I say something?
Not now, because we're going to continue the matter. You'll have an opportunity to submit your written response, and then when we come back at the hearing, you'll be able to. The court will have read that, and also you'll have an opportunity to share more information. And then, if you shared it today, it'd be premature. And
well, I mean, I don't need a continuance because I can tell you exactly what happened. So.
Okay, so I'm continuing the matter because you haven't been served, and if you've heard me on other cases, it's an issue about notice and opportunity to be heard, and we follow the rules, and the rules require that all parties are served with copies of pleadings, and they have an opportunity to respond. It puts me in a better position because I have the opportunity to read what the parties are saying, digest that, compare and contrast what each party is saying, and then come to court and hear from both parties and get additional information rather than kind of being receiving information for the first time and not necessarily having the opportunity to consider it in a more calm, less pressured environment. So that's why I'm inclined to continue the matter.
Well, what I was going to say is that you just saw us on June 5th for a contempt thing.
Yep, that's true.
And on court on June 5th, I stated my son was going on a Make-A-Wish trip on June 14th, and you had specifically said, I don't want to interfere with that. So you started contempt visits August 2nd. That's what I wanted to say.
Okay. So you can certainly put that in written form and then reiterate that when you come back to court on the 21st, and confirming that both parties are available on August 21.
Can you?
Yeah.
Mr. Connolly, are you available?
Yes, I am.
Okay. Ms. Giles?
I'm not available, but there is on the 28th.
What's your conflict with on the 21st?
I am not available on the 21st, but there is court on the 28th for change of venue.
What's your conflict with the 21st?
I will be on vacation.
And would you be able to participate via Zoom?
No, I will be out of state on vacation.
Why wouldn't you be able to participate via Zoom?
Because I'm going to be on a vacation, and it doesn't allow me to be able to do that. It's not like a vacation where I'm going to be at families or anything. It's a trip that I'm taking. And
that trip precludes you from using a phone to dial into a Zoom meeting?
Yes, because I'll be driving.
And you wouldn't be able to pull over and participate once your case is called?
No.
Why not?
But on the 28th for a change of be done with that.
Why not?
I'm the only one that can drive, and I'm driving 8 hours.
Could you pull over?
If I have to.
Okay.
But we're already going to court on the 28th, and I just filed papers the other day for a change of venue. Can it all be done at the same time?
No.
Mr. Connolly, do you have any input on consolidating the hearings on the 28th?
Yeah, I would like it to be done as soon as possible. I haven't done it for a month now, so I've kind of been waiting. I had to wait for her to get back from her last vacation. She has been gone for over a couple months. I don't know why we should push it out any further because of her vacation.
Okay. So if Mr. Connolly, you're going to mail that information to Ms. Giles. And Ms. Giles, once you have it, you can respond with it. It sounds like both parties would prefer an earlier time frame. Ms. Giles had indicated she wants to go today. Mr. Connolly indicates you'd like to not postpone this. So why don't we come back on the 14th of August? How does that work for the parties?
That works for me.
I need to be able to have time to serve him. I live all the way down in Vancouver. That's an hour away.
Sometimes the parties will agree that they can serve each other for purposes of a motion hearing via email. Do both parties have access to email?
I do have that email.
Ms. Giles, did you indicate that you said you don't have access to email?
Access to email, yes.
You don't have an email address?
I do have one.
Okay, you do.
Yes.
Okay. Do the parties feel comfortable allowing just for this particular hearing to share your respective information via email?
I'm fine with it if he can send his email address.
Okay.
Yeah.
Mr. Connolly, do you feel comfortable sharing your email address?
Yeah.
Okay. Ms. Giles, are you ready to take note?
Yes.
E
is in Edward.
A
is in Alpha.
D
is in David. Is that correct, Ms. Connolly?
Correct.
All right. And then Ms. Giles, what's yours?
Yes. It's a J.
Okay. So, and the parties are agreed that just for the purposes of this hearing, Mr. Connolly, you're going to send to Ms. Giles the motion and also the motion for contempt, a copy of the order for setting the contempt motion. And then Ms. Giles, you'll send a copy of your response to Mr. Connolly, and you'll also need to make sure that a copy is submitted to the court clerk.
Yes.
Okay, that sounds great. And is everybody available on the 14th at 9 a.m.?
On the
Yes,
14th.
I am.
Yeah, 14th is next Wednesday.
Yeah, I wrote it down.
Okay, great. So let's plan on that. So we'll see everybody August 14th, 1 week from today at 9 a.m. Appreciate everybody's patience and cooperation.
Is
All right,
there
thank you very
is there a way to get it where we can just keep doing the email like serving or not?
There is. If you're familiar with the Washington courts website, I'll just kind of walk you through this a little bit.
Well, I actually moved to also, so my address just changed. So it would be a lot easier to do email.
Sure.
I had a temp service for the change of venue, and I was told that nobody lived there. So
Yeah. So the email, there's a form. See if I can find it here. Well, I apologize. I'm not finding it right off the bat. There's two options you can look at. You can go to the Washington courts, just type in Washington courts and then forms, and then that'll pull up a listing of different forms. That's one option. You could look for that agreement to allow service via email. The other is to check with the clerk's office. They may have some idea or better idea where that can be found.
okay, thank you.
All right. Thanks. We'll see everybody next week at 9 a.m.
All right, thank you.
Thanks. I'll ask if Mr. Miller is present. Mr. Miller?
Yes, I'm here, Your Honor.
Okay, welcome to you, Mr. Miller. And then Angel Amasquita, are you on the line?
Yes, I'm here.
Okay, very good. And I see that Ms. Schaefer, the family court investigator, is present. Can you hear me okay, Ms. Schaefer?
Yes, Your Honor.
All right, very good. So we're here for a review of the family court investigator report. It was filed on June 7th, just confirming that all parties received a copy of that report. Mr. Miller, did you get a copy?
Yes, I got a copy, Your Honor.
All right, good. And Ms. Amasquita, did you get a copy?
Yes, I got a copy.
All right, very good. And then you noted, it looks like Ms. Amasquita, you noted this up for a hearing based on that report. Is that correct?
Yes.
Did you file any type of motion or you're requesting a particular relief or outcome based on that?
No, I don't think so, because I just filed it for the review for that. I didn't really know what to file it under.
Okay, so there's some recommendations that were made that Ms. Schaefer had made. She recommended that mother's visits be unsupervised, and Ms. Schaefer, you can jump in and correct me if I'm in error. That they would be unsupervised on the weekdays. It'd be between 2 to 3 hours, and on the weekend it'd be up to 6 hours. And it's okay to bring the younger child for the visit with the older child. And any visits outside of Kelso or Longview would be approved by the father and require 24 hours notice. And that Mr. Chaddock would not be present or in the vicinity of the visit under any circumstances. And that there'd be joint decision-making for school and health issues, and that no significant other or romantic interest would be introduced to the children until after 6 months of consecutive dating, and that there'd be no disparagement or negative speaking of either party or by significant others of the other party in front of the child. So that's the recommendation. Ms. Schaefer, anything to add to that?
Yes, Your Honor, if we could just clarify that the unsupervised visits are community-based only and are not to take place in the family home.
Thank you. All right, so that's the recommendation. So Ms. Amasquita, so with your review, generally, when an investigator or a guardian ad litem issues a report, sometimes the parties both agree with that, sometimes they disagree with parts or portions, or sometimes there's disagreement by both parties. Are you in agreement with the family court investigators' recommendations or in disagreement?
Yeah, I agree with her for the unsupervised visits.
Okay. And then there are some other items that I listed, conditions such as Mr. Chaddock not being present or in the vicinity. Okay. And you're okay with joint decision-making for school and non-emergent healthcare?
Yes.
And you're comfortable with the no introduction of romantic interests or significant others until 6 months of dating? Okay. And no disparagement of either party by yourselves or any significant others?
Yeah, I agree with that.
Okay. And then the weekday visits up to 2 to 3 hours unsupervised in the community, but definitely not in the home. You're comfortable with that?
Yeah, I'm comfortable with that.
And then the weekends up to 6 hours with those same conditions of being unsupervised, community-based, and not in the home?
Yes.
Okay. And you're comfortable with the requirement or the condition if the visit occurs outside of Kelso Longview, that has to be approved by the father and has to be given with 24 hours notice?
Yeah, that's fine.
Mr. Miller, what's your take on the family court investigators' recommendations?
I agree with it. I agree with the majority of it. The unsupervised visitation part, I personally have a little bit of trust issues with it, but I would have liked to get to this point. So I'm gonna agree with her on the report. Okay.
So the next step, I guess, to ask both parties, with the investigator having made those recommendations, that those recommendations then can be transferred into a temporary parenting plan that the court would then sign, and then that would be binding upon the parties, and then you'd have to follow that until there was, unless changed in the future by the court. Do you have any thoughts on that, Ms. Amasquita?
Yeah, that's fine. I don't know how it would look per se.
When you say you wouldn't know what it looks like.
I know, would it be like daily, certain times of the day, or would it be just?
Yeah, it's a good question as far as your visits.
Yeah.
Yeah, it's not specified, and that may be something that needs to be worked out between the parties. So yeah, so at that point, it's kind of open-ended. There's not it doesn't say every Tuesday and Thursday from 4 to 6 or 4 to 7. It doesn't say weekend from noon to 6. It doesn't say any of that. Sometimes parties are able to work with that openness. Other times parties are not able to do that, and they need more strict guidelines. So I don't want to pressure anybody into doing anything. If you agree on certain things, great. And it may be premature because you haven't even talked about it. It sounds like in principle, you're both in agreement with the recommendations by the court investigator. But there may be some more details that need to be fleshed out between the parties. Mr. Miller, what do you have? So I guess what I'm saying is that I don't necessarily want to take the time right now to kind of work out those details unless you already have those details in mind and there can be agreement on it. And again, I don't want to force anybody into agreeing to anything. It may be that the parties, we take some time, or you take some time to talk about, the specific times and dates for the visits. Or if you feel comfortable with kind of the more vague terms, that would be okay too. And then come back and you can tell me. So I'm fine if we want to proceed today. I'm fine if we want to take a little time to work out things. We'll hear from Mr. Miller and then Ms. Almosquita.
I think it'd probably be a better idea to just take some time to kind of work out the details, if we could, Your Honor.
Okay, Ms. Almosquita?
Yeah, that's fine, because I just have to figure out about my work schedule.
Okay. Ms. Schaefer, any input at this point?
I really just left it vague because of that. Ms. Amskita's work schedule can change from time to time, and I didn't want to lock her into something that she couldn't commit to.
Makes sense. Okay.
Your Honor, this is Beth Fellows. I'm the one that's doing the supervised visitation.
Okay.
I had a quick suggestion or thought. Is she has 2 hours on Thursdays that are professionally supervised. Maybe those could go unsupervised with those restrictions in place until maybe the next couple of weeks when you come back into court.
And is that 2 hours of supervised visitation on Thursday, is that in a court order?
I believe the supervised visitation is right now it's been scheduled as 4:30 to 6:30
Okay.
weekly on Thursdays.
All right, so that sounds like an option the parties can consider and take into account and make some decisions. Thank you, Ms. Fellows, for sharing that. I guess what I'd like to do is give the parties rough 2 weeks. We could come back in 2 weeks. You all could exchange information. I do want to see, if you don't come to an agreement, I do want to see your proposals in writing if they differ from each other. So that means you'd have to submit some type of declaration or a proposed parenting plan of what you think the contours should be and submit it to the court and serve a copy to the other party. That way I'll have a clear idea of what any disagreements are and what decisions need to be made. So we can plan on coming back on August 21st. The parties, if you come to an agreement, then you come back on the 21st and tell me what that agreement is. If you don't come to an agreement, then you would both need to write up what your respective thoughts are, the way you think things should be, submit it to the court and file a copy to the other party. Are you comfortable with that, Mr. Miller?
Yeah, I am, Your Honor.
Ms. Almosquita?
Yeah, I'm comfortable with that. And I do like what Beth did recommend too for now. Okay.
All right, the parties can talk about that. Ms. Schaefer, do you want to be included in those submissions by Mr. Miller and Ms. Almosquita?
If it helps assist the two of them to come to times that work for both people, I'd be happy to assist in that.
Okay. All right. So there's an offer of help there that Ms. Schaefer is willing to assist with that also. So we'll plan on coming back on the 21st of August. If you're in agreement with specific timeframes for visits or what have you, then let me know that. If you can't come to an agreement, then you'll need to file by next week. File what your disagreements are and what your proposed parenting plan would look like in the times, and then we'll come back here on the 21st and make a decision on that.
Yeah, I had a quick question also.
Go ahead.
Is there any way we could get off of the family wizard communication if she's comfortable with that? I know I've had technical difficulties with it sometimes where messages aren't popping up for me and I end up seeing them like a way later time.
If I'm assuming that our Family Wizard app is required by a court order, is that correct?
Yes, the current one.
So if the parties feel that do you want to have a change with that, you can submit an agreed order, or if you want to change something and Ms. Almosquita doesn't, then you could file your motion and she can reply and then the court would make a decision on it.
Okay, thank you, Aaron.
Okay. Ms. Almosquita, any final questions?
No, I don't think so. Not at the moment.
Okay, we'll see everybody on the 21st. You can either tell me if you're in agreement, and if not, you will both have filed and shared with each other your respective plans for the visits. We'll see you on the 21st.
Okay, thank you.
Thank you.
Thanks. Mr. Utter, are you on the line today?
Your Honor, my name is Amber Comer. Stephen messaged Keith Lawrence, our historian ad litem, he got called into an emergency or a work class that he could not get out of. So he is unable to attend today. I'm here. I'm his living girlfriend. So I wanted to let you know, just so that he wasn't skipping out or anything. We tried to notify Mr. Lawrence about it.
Okay, so you indicated that you're the significant other of Mr. Utter, and Mr. Utter was called away to work and he's not able to participate today, correct?
Correct, yes.
All right. Mr. Lawrence, did you hear from Mr. Utter?
Yes, I had an email that came in yesterday that represented what she just told the court.
Okay. So let me just hear from the parties that are present. Ms. Young, you can hear me okay?
Yes, I can.
Okay, great. So with Mr. Lawrence present, Ms. Young present, we're here to talk about the reunification counseling since July 24th to see what's happened. Hearing from Mr. Utter, I think would be important to know what his vantage point is. So I'm inclined to set it over 1 week so he can be present. Mr. Lawrence, do you have any thoughts on that? And then Ms. Young.
I have no objections, Your Honor.
Okay, Ms. Young.
That is fine.
Okay, let's do that. We'll note his failure to appear. And I missed the name of Mr. Utter's significant other.
My name is Amber Comer.
All right, I appreciate you letting us know kind of the situation. And if you could share that information with Mr. Utter, we'll continue the matter 1 week to the 14th of August at 9 a.m. to address.
Can I ask one quick thing? Mr. Utter is in a class. It's called the diversity training, and he's updating his insurances and such. And he's been asking for basically this entire time for Parker's social security information so we can add him to life and benefits.
Yeah, that's something that we're not going to address in open court.
Okay.
There's a lot of other people that can be addressed offline.
That's fine. Okay, I had asked. Thank you.
All right, we'll see everybody then next week. Thanks for your patience, Mr. Lawrence and Ms. Young.
Thank you.
Okay. All right, we have the petitioner, Mr. Sokchia Penn.
Yes, sir.
Very good. And you're Shannon Penn?
Yes, sir.
The respondent. Okay, very good. We're here on Ms. Penn's motion for temporary orders related to a parenting plan and child support. Looks like service was effectuated on July 10th. Mr. Penn, did you get all the documents from Ms. Penn related to her motion for parenting plan and child support?
Yes, sir.
Okay, all right. And I reviewed the response and your response, Mr. Penn, to the motion. I've reviewed your materials. I've reviewed everything that was filed up until, tell you what, last thing I reviewed. Last thing I reviewed, there's documents filed on August 5th, filed by Mr. Penn, a series of text messages, of photos of an unclothed torso. I think it's Mr. Penn's torso. And then there is a Woodland Police Report document that was filed from back in February of 24. And then there's some sealed financial documents, tax return information, some W-2s and some other mortgage statements. So those are the last things I looked at. So I think I'm ready to go. So Ms. Penn, your motion, I'll hear from you.
Are you talking about in response to what I received on Monday?
No, just basically, this is I understand this is your motion. You have a proposed motion related to a parenting plan of what you think the parenting plan should be. And then also there's a request for child support. And then also the issues about who stays in the home or what happens with the home and who pays for the home. So just all those things that you're concerned about, what you want. That's what I'm asking you to tell me about.
Yes, those are the things I would want out of a divorce.
Okay. Anything about could you share with me? I'm a little bit confused if you're both still living in the home at this point.
We are, yes.
Okay. What's your view? What's your perspective on as far as the home situation?
It's been very, very difficult. We bought the home in 2019, and just recently throughout this divorce proceeding, it's been very difficult in the home, very uncomfortable. Mr. Penn has admitted to my daughter and I, he's been seeing someone else for the last 25 years. He's put pictures of her up in this room. He's locked the upstairs of our house. I can't get up to the upstairs computer office area. It's kind of common sense to me that when you make that decision, you keep it and you take care of what you have at home and then you move on with your life, which is exactly probably what he wants to do. I'm stuck at home on disability. I guess my request would be to not change what we brought into this home, except for the fact that child support so I can pay the mortgage. The incident, as far as what's been reported, that supplemental report from the Woodland Police, I have never seen it until Monday. I didn't know he made a supplemental report. It was an incident with my daughter in Sochia. And so I grabbed him.
How old's your daughter? How old is your daughter?
She's 17.
17, okay.
And, there was no interfering of making a report to police. I didn't mind. There were no charges filed. We have an older son who's turning 29. The amount of stress in the home, it's defamation all the time. Me parenting, he's threatening to sell the home without my permission. The marriage should have never happened in the beginning. That's really all I have to say. I'm going to do whatever I can, but we cannot continue what's going on.
So what's your proposal as far as the home?
I would rather, I want to stay in the home. I want to stay with my 2 children. I'm able to afford the mortgage with help from Sochia. And that's really all. I want the children to stay stable. We've been in Woodland for 11 years now.
So when you say you're able to stay in the home if Mr. Penn pays a portion of the mortgage?
Well, child support,
Okay.
whatever was, shown on the reports.
So right now there's the 2 children, the 17-year-old and then the older adult child in the home?
No, the older adult child has been out of the home for a very long time.
Okay.
We have the 15-year-old that we share, Elias, and then Alyssa, 17, she's my daughter.
Okay, so 15 is the joint or common child, and then the 17-year-old is your child with another person.
Correct.
Okay. Okay. And as far as the child support, your indication is that Mr. Penn, what's his gross and net incomes? What did you calculate? Did you calculate that?
I have the paperwork, I believe. It came out to around 800 approximately a month.
So that's based on roughly just shy of 5,000 net, and your disability at 1673. Is that what you get?
I believe so. Whatever was sent to the court, yes.
Okay. And then the SS, the Social Security for the 2 children, that's earmarked for them, and those funds go to whom?
Me.
Okay. And then you're kind of the payee, and then you distribute those funds and caring for the
Yes.
children. Okay. 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 And so I think, did you impute your income at $2,400 per month to?
It's the total amount with the 2 children in mind.
Okay,
What I have control over, yes.
Okay, so that's the 418 for both children times 2, so 840 roughly, 1836, I guess, plus the 1673. That's what you're saying your net income is.
Yes, all the information is correct on the child support order.
On the proposed order, correct?
Yes.
Okay, so let me just pull that up here. Did you submit a proposed child support order? Did you file that?
Yes, I did.
Was it as in a bench copy that would not go in the file, or is it just a copy that would be handed to the judge?
Handed to the judge.
So let me just take a quick look at that, and then we'll hear from Mr. Penn. Okay, all right, I see. Okay, I've got those here. And then as far as the parenting plan, it relates only to the 1 child, which is the child in common. And you're recommending alternating weekend visitation time of Friday 5 to Sunday at 5.
Yes.
Okay. Okay. Anything else you want me to consider?
No.
All right, Mr. Penn, I'll hear from you on the issue of parenting plan, the home, child support.
Well, first and foremost, English is not my first language, so I want to apologize ahead of time if I did.
What's not your? What did you say?
English is not my first language.
Okay.
So I'm having a hard time understanding sometimes.
Yeah, you're fine. You're fine. If there's anything I don't understand, I'll stop you and ask for clarification.
But first and foremost, Your Honor, the house that we live in, that is the home that I bought by myself prior to me and her getting married. That's one.
When did you purchase the home?
2019. I'm not sure. I think like in October 2000. I'm not quite sure the exact date,
Okay. And when did you get married?
I don't remember either. It's like after I bought the house.
What year?
2020. I'm not sure.
Do you remember when you got married?
February 2020.
Okay. And were there any community funds used to purchase the
It's
home?
all by myself, Your Honor.
Okay. All right, go ahead.
And as far as her proposed with child support, I care for my children pretty much like most of the funding, providing everything. And for her to ask to, or for me to leave my home, I'm just confused.
So right now you're both residing in the home, is that correct?
Yes, sir.
How's that going?
I have been trying to be civil with Shannon. I try to communicate with her, but it just, there was no communication skill there at all. Lately, everything seems to be different. My stepdaughter, she chooses to go places where she please, in and out without informing, spend the night with friends. And it just yesterday, me and my friend and I happened to be outside the house, and she had a boy drop her off a couple houses up, and she walked back to my house, pretending like I didn't see anything, but I see that boy just drop her off. It's just something like that right there that I'm against or disagree. She's 17 years old, and I raised that little girl right there when she was in diaper, help raise. And for her to
go ahead and just look at me, please.
For her to let my stepdaughter to go out there and spend the night at a friend's house without asking, not that I know of, I don't know if she's communicated with her, but I disagree as far as parenting go.
Okay. Let me follow up. Earlier, you were talking about when you got married, when you bought the house. How long have you two been together?
We've been living together for like 10 years.
Okay. And then your child in common is 15. So
yes, sir.
Prior to that, you weren't living together, but living together about 10 years. Okay. And then can you tell me what your perspective is as far as the parenting plan? Ms. Penn has proposed a parenting plan that allows for residential time to you on alternating weekends. What are your thoughts about that?
I'm going to have to disagree with that one, Your Honor. The best fit for my son is to be with me in my own home, because I know I can't care for him better than she can, based on the past experience that I've known about her. Like for my oldest son, for example, according to me, she neglected him. She's been moving around back and forth many a time when my son didn't have the time and to have new friend or good friend just because of her. He had to relocate school.
And this is your older child?
That's my oldest child, yes.
Okay.
Sir. My oldest son is telling me that they do all kinds of drugs at home. This from what my son is telling me.
Remember, I want you to look at me.
I'm sorry.
I don't want you to look at her. Just look at me, please.
Yes, sir.
Go ahead.
This is what my son told me. And as you can see in the text messages that I show you, that have in the report, that's from what my son told me.
Yeah, I read those.
And besides that, Your Honor, I just disagree with her parenting. You know, all of my children, I give them all love, but they have to earn it. I don't buy love from my children, that's to be honest. My children right now, they walk all over her. There's numerous times when I'm at work, she had to call me and ask me to do something about controlling my children. Why can't she do that? I'm at work. But as far as her requests go, I'm gonna have to disagree on it. My children deserve to be with me in my home.
Okay. And then what's your perspective on child support as far as like gross and net incomes? Do you disagree with those numbers that Ms. Penn put forward?
Yes, sir. Because the income where she got it from, that's based on my normal job that I was working for,
Mhm.
which is in construction. But this past couple of months, I had to take a light duty work just because of my condition. And as far as my income go, I just make enough to cover for my mortgage and all the other expenses.
When do you have an idea when your light duty ends? As a doctor, did a doctor put you on light duty?
They asked me, but they asked me if I wanted to write a note for me.
Mhm.
I say no. Yeah, but I can't get them.
Okay, so do you have an idea when the light duty, is it going to end or when it might end?
I'm ready to go back to my regular job here pretty soon. Yeah, the reason why I had to like put all my job, postpone all my job, just because I have to come to court.
Okay.
I don't want to go back to my job and have to come to court and be distracted with my employer.
Okay, and then do you agree that as far as like the income that Ms. Penn indicates, she receives a disability payment about 1,670 a month, and then the children receive about 418, Alyssa and Elias each. Do you agree with that, or is that accurate?
I'm assuming so, yeah. I don't know anything about her, how much she did, or how much my children did. I don't.
Okay. All right. And then what you listed in your pleadings, a Discover card, a Chase card, and a Citi card with some outstanding balances.
I do.
Tell me what your thought was when you submitted that to the court for consideration. What do you want the court to do with that?
Well, that part right there, Your Honor, is my responsibility because I'm the one that spent it.
Okay.
I'm not asking her to help me like taking care of my credit card bill.
Okay. All right. Thanks for clarifying that. What's the amount of the mortgage per month?
2,200.
2,200. Does that include like taxes and insurance? All that?
Yes, sir.
That's the whole thing. Okay. All right. Okay. Any additional information you want me to consider?
Shannon, she's irresponsible, Your Honor. I have worked so hard to get to where I'm at. Everything that she has right now, I am the one that provide. My thought process, my stepdaughter, she's about to be driving. So I'll give her 2 cars. The car that she's driving now and the other one. Because I know that my stepdaughter's gonna be driving soon. And then she turned around and sold the car. I don't know what the thought process is there.
Anything else?
Anger management, mental health treatment. Because she does. She have been abused in the past. And she choose to not to follow the doctor's order. She has been diagnosed with PTSD, bipolar, epilepsy, psychosis, and a whole bunch more. The doctor prescribed her pain medicine and she abused it. That's why I'm asking. Anger management is one of them. Parenting is number 2. Mental health, especially.
Okay. All right. Thank you. Ms. Penn, anything in reply?
Your Honor, I did see a mental health professional. It's been a few years now, and she said to come back to her if I needed anything for it. And I don't. I'm okay. I'm good. I'm not taking any narcotics. I'm not taking any mental health. I take 2 pills a day for the epilepsy. I'm as clear-minded as I could be, as of right now. And I guess, I have 1 car. We're looking to buy her a car. This is just, it's a lot for me. So I really hope that, you know, I don't anticipate any changes, you know, I really don't have anything else to say. You know, that's all.
Okay. All right. Thank you. Let me ask one quick follow-up to Mr. Penn, and you may have some response to this. I just wanted to know, Mr. Penn, it sounds like from the pleadings that I read is that traditionally you've been I'll call the bread earner. You've worked jobs, worked constructions, you had a number of 1099s or W-2s. And so it sounds like predominantly you've been the breadwinner and working, and Ms. Penn has been a stay-at-home parent. Is that accurate?
Yes, sir.
Okay. Do you agree with that, Ms. Penn?
You know, it just depends on the month, you know, like, I mean, all my money and the children's money has gone to bills, you know, there's really been nothing extra. He's made, yes, absolutely twice as much as I could ever bring home some months. We separated our income over a year ago, you know, and then during the separation time, you know, he's cashed out his 401k. I mean, he totally has control of the money, and it's been very difficult. You know, it's like out of a $5,000 tax return, I got $700. You know, I mean, we're both living there with 2 children. It's not, you know, I do fear sometimes, and I'm really upset that this is happening, you know, because that's money that, you know, yes, it's his, but I mean, no money spent on the children, you know, and out of thousands of dollars over the last 2-3 years we've been separated, it's gone to him. You know, there's nothing I can do. And it's been very, very hard. I have nothing to hide, you know, I can't. So my problem is that it's just harder and harder and harder. You know, it's kind of like, if it doesn't go his way, things are going to get harder for you, Shannon, is what he said. And yes, it's at this point where something has to be done. I'm, you know, I at a loss, you know, it's a really, really sad situation. And the children, yes, have experienced it.
Okay. All right. Thank you. All right. Bear with me just one moment. Just want to clarify, there's a 2007 Kia and a 94 Mercedes. Are those cars still in the possession of the parties?
I have the 2007 Kia. The 94 Mercedes was sold.
Okay. And then that's the vehicle you use?
The Kia, yes.
The Kia. And what vehicle do you use?
Right now, I have my brother's car because my truck. I do have a truck, a Dodge 2008, but the engine blew up.
Okay. So you're using your brother's car right now?
Yes, sir.
Okay. All right. Thanks for your patience. So we're here on the motion related to a parenting plan and child support, and somewhat related to the house and the home, and also kind of the debts that Mr. Penn addressed here just at the hearing today. So it sounds like the parties have been together, you know, living together for roughly 10 years. They have a child in common who's 15. There's the older daughter who's Ms. Penn's daughter, and then there's the older child, which is Ms. Penn's daughter, not yours, correct? Or
it's our.
It's yours.
Yes, sir.
Okay. All right. Good. All right. Thanks for that clarification. Appreciate that. So what we know is that the parties are living in the same home. It sounds like it's uncomfortable at best. It doesn't sound like an ideal situation. The child is still living there. It sounds like the 15-year-old is still there, and the 17-year-old is there. And it's important that their well-being is cared for, and that they have a place to be. I don't want them to be disrupted in any way. Parents have their issues. Children are going to have some of the outflow from that, but they should be shielded as much as possible. At least that's kind of my view of things. So I'll get to the issue as far as the home. The home is really a sticky one, in that the parties have lived together for roughly 10 years. The indication is that the parties' home was purchased in sounds like Mr. Penn's name only, and then thereafter, a few months thereafter, then there was a wedding or a marriage that occurred, and so that's going to be, there's going to be some more effort on that to figure that out at this point. What I wanted to focus on today relates to the home, because I don't think it's I think it's an untenable situation for the both of you to continue to live in the home. I have concerns that there's been, you know, the issue of violence is raised up, at least in you know, the February police report. So I'm concerned about that, and I want to keep a lid on things. I don't want things to go south. So with that in mind, and with in mind that the children need to be stay in the home, I want to address the parenting plan. So the parties are going to go your separate ways. If you haven't already gone your separate ways, you're going your separate ways, and so that means the parenting time with the child, the younger son, needs to be addressed. My sense is that Ms. Penn has been the stay-at-home parent that's cared for the family, and I know that Mr. Penn has concerns about what that care has been and how that's occurred. And Mr. Penn has been traditionally the breadwinner. There's been the disability income that comes through, but traditionally he's, he gets phone calls about how to handle the children, kind of needing reinforcements and the like, and he's been traditionally at work. So that's kind of the general sense I get from that. So that the general parenting, the heavier parenting responsibilities, kind of the day-to-day, the emotional support, not necessarily the financial support that comes through working on a regular basis, has fallen to Ms. Penn. So based on that, I'm going to nominate her as the primary custodial parent, and then the visitation for Mr. Penn, and again, these are temporary orders, will be alternating Fridays from 5 p.m. until Sunday at 5 p.m. And if I'm also fine with a midweek visit. Generally, those happen every week, and that'd be from 5 to 7 p.m. For Mr. Penn. As far as the child support, I think it's fairly straightforward, at least for Ms. Penn. Her income is roughly that 2,400 level. The numbers that were presented, those numbers don't change. They're fixed. There's documentation supporting that. And then with Mr. Penn, his income sounds like he's on light duty. It sounds like he's getting better, and he's kind of at a position to go back and work full time. He's been a good income earner. So I'll set his gross at $6,000 a month, and his net income at $4,947 per month. So I'm giving my ruling at this point, and then if you have any questions, just take note and then ask them when I'm finished. So I'll make that finding and then set the child support based on that, based on those figures is roughly $800 a month. That child support payment will be due on the first of each month, with September being the first month. It'll need to pay through the registry. There's a division of child support. They receipt the money, they receive it. There's a third-party record that they make, and then the funds then are forwarded on to the other parent to be spent for the benefit of the children. So that's kind of the child support. Sounds like you had a question on that, Mr. Penn.
Yes, regarding the child support, my employment right now, I'm making $20 an hour.
Mm-hmm.
So wherever she come from, I don't make that much anymore, Your Honor. Right now, I'm making $20 an hour. And as far as my house go, I am responsible for my house. Everything is under my name. If I don't pay the mortgage, and the house is going to be up for closing or up for sale.
Yeah, that's a good question. So the income that I'm setting for you is based on the variety of tax documents that you filed. It looks like either 1099s or W-2s, and that's been a kind of a historical income earning level. So that's what I'm setting it at. As far as the home, we'll get into that since I addressed the parenting plan. As I said, the arrangement of living together is untenable. So therefore, I think the children need to stay in the home. And if Ms. Penn is the primary custodial parent, that means that Mr. Penn, you'll need to be moved out by September 1st and need to live elsewhere. And then you're also going to be, Ms. Penn is going to be required to pay the mortgage with her funds and also the child support that you pay, so that she'll be required to pay that. And I don't want to see you, not paying the child support as a means to control the situation as far as the home. That's your obligation to provide for a home for your children, and then the rest of that is going to be sorted out as we go forward. Whether the house is sold, whether whether you move back in or something that's going to be figured out later. This is a temporary plan that I'm laying down. So there's that issue. There's the other issue relates. Pardon me, the move out date is September 9th. I wanted to make sure that there's a full month there. So the move out date is September 9th. As far as the property, the Dodge truck goes to Mr. Penn. The 2007 Kia goes to Ms. Penn. The mortgage is going to be paid by Ms. Penn, and also the utilities, the Discover card, the Chase card, and the Citi card. That'll be the responsibility of Mr. Penn. I'm ordering that there not be any change of an insurance for any medical, health, life, property, auto insurance policies that may be in place. And as far as the parenting plan, just so the parties are aware, it's joint decision-making for school and educational issues and non-emergent healthcare. So need to confer on that. I'm not making any rulings on holidays. The parties will do their best to work on that, to come up with an arrangement that works for all parties. And I've signed off on the parenting plan, the child support order. Just be aware that any healthcare costs that are not covered by insurance will need to be split 50-50 between the parties for the children's benefit or the child's benefit, because that only applies to the one child. And I think that covers the general gist of the orders. I'll ask Ms. Penn if you have any questions, and then Mr. Penn if you have any questions.
Right now, for the last few years, I've been paying half the mortgage. And then I take the check to the bank because it's in his bank account. It's automatic withdrawal through his bank account. So like today I would go deposit the $1,045 because I was told the mortgage was $2,090. I didn't know it had gone up to $2,200. I was never told that. So I guess after to address after, around the month of September, because I will be depositing the half of the mortgage, what happens after that, because do I just keep depositing? Do I deposit the full amount into his bank account? You know what I mean? I just take a check to US Bank. That was my question, what to do about them.
Yeah, usually mortgage companies don't accept partial payment. They want to accept a full payment, right?
Well, we decided to, take care of his financial issues, and my credit was last and I was on disability, and that's why it's only in his name. So I don't know if I call them, the mortgage company, if they'll give me any information, you know what I mean? As far as, or do I just send the check directly to them next month?
So you deposit the money and then Mr. Penn makes sure that the mortgage is paid.
Right.
Okay.
That's how it's been.
Okay. Mr. Penn, any disagreement that arrangement should continue?
Your Honor, the loan is under my name. Everything's under my name, not in her. And we agreed to that, which she's been doing that partial of her rent for the mortgage payment.
Okay. So sounds like she's paid half and you've paid half. Any disagreement that continues?
Yes, sir.
Okay. Do you want to explain why?
Like this continue as.
So what Ms. Penn is saying, she's saying that in the past, the mortgage has been paid. She pays half into your account, and then you pay the mortgage, you use those funds, and you contribute your funds, and then the payment is made to the mortgage company.
Yes, sir.
So my question to you is, my sense is that should probably continue. That way, that safeguards your interest in the home and make sure that the home doesn't go into foreclosure, and you might potentially lose any equity that you have in the home.
Yes, sir.
Okay. So as far as the payment, both parties are, so initially I said that Ms. Penn is responsible for the payment. That may not be workable based on kind of the situation that we're in. I'm fine if you continue to pay the $1,045 per month into that joint account, and then Mr. Penn would be responsible then for paying the full amount of the whatever remains, whatever his half is of that, so that everything's current, it stays current.
Okay, yes, it's not a joint account. That's
Just a single account to his.
Yeah.
Okay. All right. Any other questions?
No, Your Honor.
Mr. Penn, any questions on your end?
Your Honor, everything in my home right now. I mean, I have so much stuff, like all my tools, everything that I use for my work. Am I not allowed to be back in my own home, or how does that work?
So that's the thing with the temporary orders. There's a lot of unknowns and a lot of vagary that's necessarily present. My sense is that it may be difficult to relocate all of those tools, because if you're in the trades, generally folks that are in the trades have a lot of tools and they need to be safeguarded. Ms. Penn, do you have any concerns if he would? I don't know if they're in the garage, and if you'd feel comfortable if you came to the home to retrieve tools when needed, or I don't know.
I mean, I have no objection. I just.
We have no garage on them.
I mean, I just want, things need to cool down, I mean, I don't have any objection as long as there's no defamation of me, I don't want the name calling or the, I'm a bad parent type thing in front of the kids, as long as it's a comfortable condition, absolutely. He can leave the tools or whatever he needs,
Okay. All right. So as far as, I think so the clarification that there's no garage, because that's what I had envisioned and that was incorrect. I think at this point, it can be modified in the future, but I think in your possessions, that it's basically going to move out. If the parties want to agree to something different, that's fine. But I think the court rule is that there just needs to be a clear division. She stays in the home, you find a different place, and you can take your tools and your possessions with you. Any other questions?
No, that's it.
All right. I've signed off on those orders. If the parties want to get copies of them, you can check them in a little bit. I'll ask Mr. Penn if you just stay behind just about 5 minutes. Ms. Penn, you'll be free to go.
Okay, thank you.
All right, thanks. And if Mr. Penn, if you feel comfortable, you can just take a seat in the gallery, and I'll just set your watch for about 5 minutes, and then you're free to go. Appreciate it. Thank you. We have 2 matters left. I apologize for the delay, and I appreciate your patience. Good afternoon. I'm just a little bit concerned. I told Mr. Penn to remain in the courtroom. He just left. Yeah, I need the police up here. Yeah, just run out there and just let him know you're supposed to stay in the courtroom. I'll get the officer up here in a second. Apologize for the delay. We'll just need to deal with this, and then we can proceed. Okay. Thank you, Madam Clerk. Thank you, Mr. Penn. I appreciate that. I saw you left and I was just concerned, so I appreciate you coming back in. Thank you. We're here today on Ms. Cuevas's motion for temporary orders, and I want to just ask first, I saw some service of some documents that you had served upon Mr. Cuevas. What was served was a petition, a notice of hearing, a proposed temporary family law order. What I didn't see was a copy of your motion for the temporary family law order, nor did I see a copy of the sealed financial statements that you had filed with the court. Were those documents given to Mr. Cuevas?
Can you repeat?
I sure can. What I saw, Deputy, thanks for coming up. I appreciate that. I had just asked Mr. Penn, who's here in the front seat. I'd asked him to remain. I asked him to remain while the other party left, and then he exited the courtroom, and I didn't know where he went. But the clerk, he was here, and the clerk just kindly asked him to come back in, and he gladly came in, and so no issues. So, thank you. All right. So the documents that I had were the following that were shown to be of served to Mr. Cuevas. This is what I have. And I'm looking, this was filed on July 23rd. This is the proof of personal service. It looks like Angela Gamer was the one that did the serving. And she served to Mr. Cuevas a petition for divorce, a notice of hearing for a temporary family law, that's what it says, and then a proposed temporary family law order. So those 3 documents were served upon Mr. Cuevas. What I didn't see was served on him was a motion for temporary order that was filed on July 2nd, and a sealed financial source document that contains roughly 35 pages, tax returns from 17 through 2023.
Okay, so
I say that, and because my concern is notice and opportunity to be heard. So I think there was an effort to get all the papers to him, but I don't think they all got to him.
So everything that was filed with the court, he received a copy of everything.
Okay.
The only thing that when I was going through my paperwork, I have my declaration that didn't get filed because I needed to make copies. And so that's the only thing that he hasn't been served with is the declaration.
Okay. All right. So that very well may be the case. And the way that, if an appellate court were to be reviewing all the proceedings here today, they would look to see what's been filed, and they would turn to and look at these affidavits or declarations of service or proof of service to see what has been filed. And so that's kind of what controls.
Oh, okay. What the little boxes that were checked.
Yep.
Okay.
Yeah.
Gotcha.
Yeah. And so that I have to abide by that. So it very well may be that he received that, but I think it's a better practice to make sure everything's done properly. All the boxes are checked so we know exactly what was or was not given to Mr. Cuevas or vice versa.
Okay. So you're saying I need to give him another copy of the tax returns?
Not necessarily. What I'm saying is that the proof of service is inadequate. The proof of service says that some things have been given to him, but not everything has been given to him, when in effect, everything may have been given to him. And it may seem like form above function. I get that, but the form is important. So that way we know things are not missed and everything is done correctly. So, And too bad I didn't call your case earlier in the docket. I usually try to do that when I know that the case is going to be a little bit short because of service issues. You notice probably at the beginning, I called those cases, and I apologize. I was a bit rushed this morning and I didn't get to that. Otherwise, I would have called you earlier. So I think what I'm saying is that we need to continue the matter. So one of two things can happen. If Mr. Cuevas has been served with all of those documents, then an amended proof of service would need to be filed. If Mr. Cuevas has not been served all those documents, then he'd need to be served whatever documents he hasn't already received. And then a proof of service saying, hey, these documents were served upon him. So that's kind of where we're at.
Okay, and you're saying that according to that paperwork that he did not receive the sealed financials
Correct.
and the motion for
The motion, the motion itself that was filed on July 2nd. And then it sounds like you also had a declaration that you want to file too.
It's been filed. It just hasn't been. I filed it today because when I was going through my paperwork, I was like, this is super important.
Yeah.
This didn't, and because I had to put a notation that I needed copies.
Right. So that declaration, I haven't read it either. So
yeah,
that's going to be, it's important for you. It's important for me. It's important for Mr. Cuevas. Yeah. So long story short, we're going to continue the matter. And then what'll happen is that Ms. Cuevas, you'll either do those one or two things, the amended proof of service or making sure all the other omitted documents are sent to Mr. Cuevas and then a proof of service filed. Then once Mr. Cuevas receives that, then he can file a response, file it with the court, make sure you give a copy to Ms. Cuevas. And that sounds like you'll get your declaration filed, and you'll give him a copy and do the proof of service for that also.
Yes, because as of now, I've received no response either through mail, post office box, nothing.
Right, exactly. Yeah, 'cause I know what you want me to know, kind of, except for your declaration. But I don't know what Mr. Cuevas wants. So you'll have opportunity to file your documents and your points of view and declarations and any supporting documents. And Mr. Penn, if you want to go, Mr. Penn, if you want to go, you're good to go. You're welcome to stay too. Yeah, you're free to go if you want. Yeah, thanks for staying behind. I appreciate that. That's very gentlemanly of you. Thank you.
Your Honor, I need some time to put some money together. I don't have any money right now to get a lawyer, get an attorney. So I need at least 1 month to put some money together to get some legal help.
Okay. So it looks like the service of the documents was back in the middle of July. So you've had since July 14th roughly until now. I'm going to continue this matter another 2 weeks. Hopefully that'll give you enough time to find an attorney. I recognize having an attorney.
No, it's not. I cannot find it. It's just that I don't have the money to hire an attorney. Okay. That is my problem. I've been meaning, but cannot put the money together.
Okay.
Your Honor, I don't have money for an attorney either, and I'm doing it on my own. And Mr. Cuevas is a very smart businessman, and I don't think he's redundant. I think he could manage to do this.
Yeah, so there's competing demands here. Ms. Cuevas has filed a petition. She's filed a motion. She wants it to be heard. Doesn't want it to be delayed too much. And the competing concern is that you want to get money together to get an attorney to help you with this process. So I think I'll kind of just do my best to kind of split the middle and set it over 2 weeks. That'll allow you some time. That'll allow you some time to find an attorney. But if you can't have an attorney, if you don't have an attorney found by that time, then you'll need to have responded to her request, and we can talk about it at that time.
Yes, because I completely disagree with all this. Is completely out of the line. Completely, half of this is a lie, and a lie.
And that's why you'll have an opportunity to supply tell your side.
That's the reason I do want to get an attorney to get legal help, because I know myself, I am a smart man, but as she said, I'm not I don't know much about the legal papers. So I don't even know where to get these papers to fill them up myself.
Well, and I'll just offer to both parties, there's a good resource online. It's called WashingtonLawHelp.org.
Yes, I got the phone number from outside.
It's a great resource. There's a clear hotline, and the clear hotline is staffed by attorneys. They speak both Spanish and English, and there's numbers that you can call if you'd like to call them. That's an option also. So we'll continue this matter to the 21st of August, and we'll expect to have a response from Mr. Cuevas. So your response And then we'll expect to have that either amended proof of service or additional proof of service with additional documents served.
Okay.
Any questions about kind of
No.
steps forward?
August 21st.
August 21, 2 weeks from today, 9 o'clock. All right, if there's no further questions, then the parties can work on those things and we'll be back on the 21st. Thank you, Ms. Morgan.
Thank you.
Yes.
Okay, welcome to you. Jonathan Morgan, are you on the line today?
Yes, I am.
Okay, welcome to you, Mr. Morgan.
Thank
All
you.
right, we're here on Ms. Morgan's motion for temporary orders. It looks like service was proper up to Mr. Morgan on July 19th. And we're here talking about some vehicles, some bills, cellular bill, fiber loan, storage unit, and a request for spousal maintenance and the like. So that's what I know as far as just kind of in general overview terms. And I'll just ask the parties if that's kind of what you're anticipating is going to be covered today. Ms. Morgan?
Yes.
Okay, Mr. Morgan?
Yeah.
Okay. All right. So I'll hear from the parties. Ms. Morgan, you're the moving party, so I'll hear from you first, and then I'll hear from Mr. Morgan, please.
I was just asking for spousal and the other stuff to be help paid because we got together August 19. We got married August 21st, 21. And he is trying, and we started living together January 14 of 20. And then we bought a trailer in September of 22, lived in it until April 24. And that's when we stopped living together is April 20th of 24. And we fully separated January 18th of 24. I'm stuck paying the trailer, which I feel, yes, it's in my name, but my grandfather signed for, co-signed for us because Mr. Morgan could not get on the loan with me, so we could live in the trailer because we had to move out of our apartment. Also, our storage unit, half of the stuff in there is mine, half of the stuff in there is his, so I feel he should have to pay half of that.
And is that the storage unit I had listed, the cost for that is $260 a month?
Yes.
So you're asking each to pay half?
Yes.
Okay, go ahead.
And that storage unit also includes, I'm having to store the trailer there because I cannot afford to live in it and pay rent somewhere else for that right now.
So the trailer, is that the 2019 Coachman?
Yes, Your Honor.
And is the trailer, is it an RV or is it a mobile home?
It's a travel trailer.
Travel trailer, okay.
Yes.
And what's the monthly payment on that?
$295.
And in your paperwork, you indicated that you wanted to keep possession of that. Is that correct?
Yes, Your Honor.
But
I need to fix it up and get it sold, so I just need to keep it in possession right now. It's
Okay.
in my possession.
Okay, and in the meantime, there's a $295 a month obligation for it.
Yes, the monthly payment for it, yes.
And who are you proposing pay that?
I feel it should be split since we bought it together. It's just in mine and my grandfather's name because Mr. Morgan could not get his name on the loan. So my grandfather was nice enough and helped us get a place to live.
Did you live in that travel trailer together?
Yes, we did. From September 20th, 22 until April 20th of 24.
Okay, all right, thank you. And so then, why don't you talk to me a little bit about the spousal maintenance request?
I feel that because, I only make $900 roughly a month right now. I was on Social Security, and I've been on Social Security since I was about 15 years old because I have other issues. I was wrongfully cut off in February of 2024 because it's just a whole thing. They didn't file a paper that needed fine, so they're getting me right back on it. I've been going through the process again. And I just started a job in May, and I'm part-time because I'm a caregiver, so I have to go through all the training, and I'm getting put on full-time as soon as I'm done with everything.
When will you start working full-time?
I'm not completely sure. It's whenever they can get me, because right now I only have part of my certifications. So when I'm fully certified, I can be full-time.
What are you making part-time now?
I make 20 an hour.
And if you go full-time, is there a wage increase?
No.
Okay. And so how many hours a week are you working now?
About 13.
Okay.
13 to 28.
And then the $900 a month, what's that designated? Is that Social Security disability,
No.
Social Security income?
That's my whole income. That's just working. I don't have social security right off the second.
Oh, okay, so that $900, that's based on your part-time job.
Yes.
So currently you're not receiving any Social Security or any other payments?
No.
Okay. All right. And then tell me a little bit about just the cellular bill and the fiber loan.
The fiber loan. So the fiber loan is like two different things. We did the fiber loan first. I went to Idaho to see my friend and we agreed I could take a loan out, and then I didn't end up using that loan, and we used half of that to put down for the trailer, like for a down payment for the trailer when we bought it. And then the other half is we went back to fiber and asked for them to give more on the loan after we'd paid it off a little bit so we could get our cats fixed.
Okay.
And both of our names are on that loan.
So it's a joint loan. And that monthly payment is $100?
Yes.
Okay. And then you're asking that the Jeep stay with you, the
Yes.
trailer stay with you, the Subaru, the Nissan stay with Mr. Morgan?
Yes, Your Honor.
Okay, and the Visa credit card that ends in 0973?
There's two Visa credit cards. One is his that he should have full for, and then mine. We each have our separate Visa credit cards.
What are the last four of your card?
I don't have my card. I don't use it, so it is shredded, but his is 0973.
Okay, all right, thanks. What other information you want to share with me, Ms. Morgan?
You were asking about the US Cellular, the phone bill.
Yeah.
I feel I can pay the monthly payment on it, but I feel he should pay. I don't know how to explain this. So when you go and buy phones, you have like the monthly service part, and then you have like the actual phone part, I guess, if you don't pay outright for it. Those were gifts for me. My phone was my birthday, my iPad was my Christmas present. I feel he should pay that, and I should just only have to pay the monthly service fee.
So what's the division of those two elements?
I know the monthly bill is around $350 a month. But I also can't get into, all of it's in Mr. Morgan's name. So I cannot get into the full stuff. If that makes sense.
What's the division between just the cellular service and the hardware?
I guess I don't.
It's okay if you don't know.
I don't know. Sorry, I don't know how to answer that.
It's okay. All right. What other information do you want to share, Ms. Morgan?
I think those are the main things.
Okay. All right. We'll turn the time to Mr. Morgan. Mr. Morgan, what's your viewpoint on all this?
Yeah, I'm here. So during the time periods of all the loans that she got, and the phone bill and the storage unit and credit cards, because she also listed a Visa credit card of gas money on her part of the paperwork that she was wanting me to pay for some unknown reason. That Visa credit card for the gas and that storage unit and any other loans that she is requesting me to pay. Yes, a couple of those loans were in fact when we were married, but all the other, like the storage, the credit cards and stuff like that, were long before we even got together. We were not living together. We were dating before 2019. So we were dating before 2019. But we did not move in together until June of 2020. At that time, yes, she was working all the way up until her mom died, and then after that she stopped working. All she had was Social Security, and after her Social Security got revoked from her possession, I ended up having to pay all of hers, including mine,
including her street payment, the trailer payment, the phone bill, her storage, and all of her credit cards and mine. So in that long time span of from when her mom died and her Social Security stopped, I had to pay everything. Because of all of that and all the stress of trying to get bills paid and trying to get everything done so that way we have a roof over our head, I ended up getting medical issues, having seizures. It shows in my doctor's notes and paperwork that I did turn in, including all bank statements saying what her bills were, what mine were, what I have paid for bills, what money I have gotten returned from overpay to her to pay whatever bills needed to be paid. I will say she did have access to get online on the mobile app for US Cellular and look at our phone bills. The paper also leading for US Cellular is technically a separation of phone bills. For her to
Do you know the
take
division between the hardware and the cell service?
So the cell service and the hardware is fully separated, is to be separated. That's why you have the US Cellular paper in front of you, or she does.
So I'm asking you if you know what the division is, what amount applies to the service, what amount applies to the hardware.
So the division for the paperwork or the division for the phone bill is $77 a month for her half. For her items, for her service and phone and tablet.
Okay.
For both services and hardware. Right now I am also very behind in bills, and I just realized that I have to renew my tabs because my tabs expired on my car. I am behind a couple $100 due to car insurance. So, and plus my job, I'm not making a whole lot there. My checks are just under $600 a month, or I'm sorry, a week. So I am behind on paying rent. I'm behind. I just got my cell phone caught up, or cell phone bills caught up by dropping one full paycheck to pay that full amount. So that way that I cannot be behind anymore. And I'm going to have to do the same thing for my car insurance because I don't make enough to proceed to pay all of my bills accordingly. Yes, we did get the trailer while we were married. I was not able to get on that due to my credit score being so low. I will say, yes, I went and signed a paper for loans, but I was not able to fully have my name on the loan due to my credit score was being so low. The bank even told Cherish and I both, because my credit score is too low, my name cannot be on the loan. One of the loans was like $300. That loan, I did give her the money to pay that off in full while she was not working and refused to get a job. Also, with the other loan being much more, so during our wedding, yes, her friend did come down, but we had to drive her friend all the way back to Idaho to take her home, and we had to get a hotel room for that night while we stayed there for I think it was like a night or a couple days. I did have to pay that out of pocket. We never used that loan for any of those expenses.
So let me just focus a little bit more. So the fiber loan, it looks like it's $100. Is that $100 total, or is that $100 a month payment?
That's $100 a month.
Okay. And then the storage unit, do you agree with Ms. Morgan that it's set at $260 a month?
I do agree to that, and it does show in my bank statements that it is that amount. But yes, I do agree that my stuff is in there as well. But and all I want is a couple things out of there. Other than that, she could sell the rest of my stuff. I don't care by this point because I don't have a lot of room where I'm living at now.
Can you tell me a little bit about your living costs? How much you pay for rent?
So my my total amount in bills right now is $2,368.54. And that includes rent of $471.25. Utilities plus my phone is $525.73. My car and maintenance is $818.97. Personal expenses is $86.59. Household expenses is $333.
What is that
And
comprised of?
I'm sorry, what was that?
What is the $333 comprised of?
Groceries.
Okay.
Other expenses like a few small subscriptions I've gotten is $136 even.
Okay, thank you. I just need to step in a little bit. I have another docket that starts at 1 o'clock, and so I'm gonna try to expedite things. I'm gonna ask Miss Morgan. Miss Morgan, what are your monthly living costs?
Right now I can't afford it. I'm behind also. I'm supposed to be paying $400 in rent, and that includes like the water, sewer, garbage. And then I have groceries, about $250 a month. And then gas, it's probably about, I put 150 to 200, just depends, because I drive for work, so it just depends how much. Car insurance is 160. My car payment is 430. I have a Les Schwab's loan that's $75 a month. Visa credit card, $30 a month. Regular, it's a Ulta MasterCard, $41.
And total expenses, what does that tally up to be every each month?
And then I have the storage in the trailer added onto those.
Right, the trailer's $295.
Yes, and the storage is $260.
What does that all tally?
I don't have a calculator. I don't have a calculator, and I'm not very good at math.
Okay.
Can I mention one more thing, Your Honor?
You can. Before you do that, I apologize. I was hoping we could get things done a little bit quicker, and that's okay that we didn't, but I have to travel to a different location to be at that 1 o'clock docket. So I'm going to have to continue this matter to next week, and I apologize. We kind of got halfway through it and we don't get a finish up, but what we can do, we can take this first on the docket or very close to the docket next week and have it heard at that time. And again, I apologize, we didn't get to it. So hopefully both of you are available next week on the 14th of August. Are you both available, Miss Morgan?
Yes.
Mr. Morgan, are you available?
Yeah, I have to take another day off work, but yes.
Yeah, I apologize for that. So we'll continue this. I'll save my notes from today's hearing, and then we'll see everybody next week on the 14th at 9 o'clock in the morning. The other matter that's slated today, which I wasn't made aware of until earlier or in the middle of the docket, was the Bissig and Gibson matter. So I don't know if the Bissig and Gibson parties are present.
I am, Your Honor. My name is Megan Gibson.
Okay. So my apologies. So normally what happens is that the docket is loaded up and I review it. Apparently there was a miscue and it didn't get loaded up, so I didn't know it was on the docket. And then midway through the docket, I found out it was on my docket. I haven't read anything. I don't know anything about the case, unfortunately, and we're out of time today. So my apologies for 4 hours of your time this morning. It's significant. What I would ask if both parties, Ms. Gibson, Mr. Bissig, if you're available next week.
I was going to ask, Your Honor, if we could potentially postpone it for 2 weeks. I am taking my children on a camping trip for a week coming up this week, and I won't have service.
Okay, Mr. Bissig.
He's not present, it doesn't look like, Your Honor.
He is, and I'll ask him to come forward and just maybe get to the microphone so everybody can hear his voice. Because I can see him, I can hear him, but the rest of you on Zoom probably can't. I apologize. So you're Mr. Bissig, correct?
Yeah, I'm here.
Okay. So there's a request to continue the matter by myself, and then I suggested the 14th. Ms. Gibson suggested the 21st. Do you have a preference?
No, it's fine.
Okay. Well, let's set it over to the 21st, August 21st. That's a Wednesday at 9 o'clock in the morning. We'll set it to that date and time. And let me just double check to make sure because I haven't looked at the case at all. It looks like there was proper service. And then have you filed anything in response, Mr. Bissig?
No, I didn't know I needed to.
Okay.
But it'll give me time to.
Yeah, if you want to, you can certainly file that with the court and send a copy over to Ms. Gibson so she has awareness of what you're saying. So we'll reconvene on the 21st. Ms. Kell, does that work for you, the 21st?
It does. I'm a little packed in on other matters as well, so it'll be a similar situation where I'm bouncing around, but I'll be here the best of my ability.
That's kind of you. I appreciate that. Thanks.
All right.
All right.
Thank you. Thank you, Your Honor.
Apologies again, and we'll see everybody on the 21st. All right. Thanks.
Thank you.